Order. Order. Would everyone ensure that all electronic devices are turned off or switched to the silent mode? Tea and coffee are not allowed in the committee room, and we are continuing the line-by-line consideration of the terminally ill adults end-of-life bill. I remind members that interventions should be short and raise points of clarification or questions. They should not be speeches in and of themselves. Members who wish to speak should also bob and to continue to do so throughout the debate if they wish to take part until they are called. When members say you are referring to the chair. You should not be used between each other during the debate. So, I believe Jack Abbott. Cliffhanger.
Very much, Madam Chair. I feel a huge sense of responsibility for my EastEnders-style ending there. And unfortunately, it's not going to be as radical as I'm sure people were hoping for. But back to the point I was making about bandwidth or capacity of the professionals involved in this process here. I'll be really frank, as I said earlier, and members opposite, although, as I was saying, we've been very good at leaving party politics at the door, have on a couple of occasions mentioned the state of the NHS and the wider healthcare system. I could probably go further and mention about the huge backlogs facing the courts and the wider criminal justice system. However, in saying, and it's a point that I've considered quite deeply, and I think it's fair enough to consider in the wider context. I know members from across the House have done so. I'd probably mention, and I think it was a point raised earlier about the panels, about whether or not there is capacity in the system to support panels, i.e. are there enough psychiatrists, are there enough social care workers. However, I must say that it's, in my view, an inconsistent argument to then also say, well, actually, we need more psychiatrists and more social care workers in other areas of the process. I'm not sure we can have this both ways, if I'm completely honest with you. While I think it's a point for consideration, and certainly one that the committee has discussed, I think ultimately it will come down to members of the House on that opinion. I don't think we're here actually necessarily to debate whether or not the systems we have in place can have an assisted dying bill coming through. I would also probably, and this is a conclusion that I've reached, is that actually whether or not there is an introduction of assisted dying into our healthcare system, judicial system, etc., that is not going to fundamentally change the challenges that we face as a country in these areas, in my personal opinion. I do not think these will make a substantive change in these areas. And I think what we're here to do is to make sure we present back to the House a bill that has the safeguards in, with the balances that I've mentioned previously in my speech this morning, that it can progress. Certainly I wouldn't want to produce anything that paralyses the system, but I don't think in any shape or form this particular new clause with this panel approach will do that. In fact, I actually think this will in the long run help this process along. So for that reason, I'm not sure whether capacity of professionals is a valid argument to argue against this panel. I think, if anything, quite the reverse. And so, to sum up, Chair, as I said, it really wasn't worthy of an EastEnders cliffhanger, that last point I was making by your predecessor in the Chair. But I would, obviously, and I think we've had positive murmurings and acknowledgements about new clause 21, Amendment E. But as I say, to sum up, I think this panel approach represents a huge leap forward, and I appreciate members in the room and across the House may say, well, it doesn't go far enough. And I go back to my earlier point. I think for some members, no amendment, no changes, no safeguards will ever be enough people to support the bill. But I think what we've got to do as a committee is come out with the process and a settlement which is strong, robust, puts the patient first and makes sure we're acting in their interests as well. And for the points earlier, I really don't want any person or individual looking to go down this route, whilst obviously making sure they're safe and they have capacity to make these decisions. I don't want them to be stuck in endless meetings or courtrooms or whatever it might be, when they should be spending time with their loved ones as well. So I think this strikes the right balance between safeguarding, bringing in all the professional expertise that we've been looking to do as a committee the whole way along, whilst making sure this process is fair and equitable as well. So I urge you to support Amendment E, but I will also be supporting the new clauses today. Thank you.
Danny Kruger.
Thank you, Chair. I'm going to speak to the clause as a whole and to the stand part debate and bring in some of these amendments as I go. At the second reading of this bill on the 29th of November, the Honourable Member for Spen Valley said, and I quote, "Under the bill, any terminally ill person who wants to be considered for an assisted death would have to undertake a thorough and robust process involving 2 doctors and a High Court judge. No other jurisdiction in the world has those layers of safeguarding." Now, there can be no doubt that the High Court judge safeguard was presented to the House as globally exceptional and unusually thorough and robust as compared to other jurisdictions, and it was also a prominent feature of the public campaign around the bill. We were told it was a bill designed for exceptional circumstances with robust safeguards, of which the High Court judge was the preeminent one. This is not a trivial detail in the bill. It was the centrepiece of a safeguarding regime arranged around a small number of deeply vulnerable people. Over 60 members of Parliament are on the record as saying that it was this safeguard that helped persuade them to vote in favour at second reading.
Well, I'm going to give way.
Happy to give way.
I will stand corrected if this is not true, but my understanding is that Hansard will show a very different story. I don't think 60 people got up on the record and said this was why they voted for the bill.
Danny Kruger.
Thank you. Well, to be clear, I wasn't suggesting that they all said so in the second reading debate, because not everybody spoke in the second reading debate. And nor am I saying that it was only because of this safeguard that people voted for the bill. But there are 60 colleagues of ours who have cited the judicial safeguard as a reason for supporting the bill. So they have referenced it as a safeguard. And indeed, I hope the committee will agree, it has always been presented, it was always presented as, if not a very significant aspect of the safeguarding regime. I suggest it was the most significant because it was the one that enabled people to argue that this was the strongest bill in the world, because of, members have said, other regimes don't have a judicial element to them. Now, I opposed the bill at second reading, and I expect I'll oppose it at third reading. But I do respect the committee process enough to accept that the House wanted the bill debated, the bill that we passed debated. Because I respect that process, I have not opposed motions for clauses to stand part that concern the heart of the bill. But we're now going to see the Honourable Lady and government ministers and their supporters vote against a stand part motion of the essential safeguard in the bill, the principal element that was used to persuade the House that this bill was safe. I think it's an extraordinary thing that we're going to see the proposer and the government oppose a stand part motion for the centrepiece of this bill.
Will you give way?
Happy to give way.
Thank you, Chair. I understand his framing of this, and that might very well be his perspective, but there were 650 MPs who voted on that day, and I think it's unfair to represent colleagues who didn't have that view, that this is the central component of the bill. There are lots of other components to the bill that colleagues have certainly spoken to me about, and I think it's important to acknowledge that.
Well, I'm happy to acknowledge there are very many other components of the bill, but as I've said, many members, including the Honourable Lady, cited this safeguard as, if not the essential element of the safeguarding regime. And crucially, it was presented to the House of Commons as such, and it's a central clause of the bill, and she is now proposing to vote against that element. Now, my view is that a change this substantial, a fundamental and radical change to the structure of the process that's being designed, that should be presented at report stage. The whole House should have the opportunity to discuss and debate properly whether that element should be changed. Every member should have the opportunity to have a say on this central point. Happy to give way.
I thank the honourable member for giving way, and you'll still have to forgive me as a relatively new MP. There are still bits of parliamentary procedure I've not yet got my head around. But would it not be the case that MPs would have that say at report stage when they could table an amendment to take it back to how it was? So it is fair that that point could be debated at report stage.
Well, I mean, of course that's correct. There will be a small number of amendments that will be selected for debate and vote at report stage, and that might indeed make it through the Speaker's selection if somebody wants to table that amendment. But the point of the committee process is to consider the bill that was passed at second reading and to come back to the House with the bill either unamended or amended. This is a very, very substantial change to the bill as presented and voted for at second reading. As I've said, many members were very in support of this clause. No doubt the honourable member was too. Happy to give way.
Thank you, Chair. I think he's making exactly the point that I think we probably, hopefully, all agree with, that this is the job of the committee. And the job of the committee is to take the evidence, is to look at the bill as it was, and to look at ways that we can improve it. And I think on the basis of the evidence that we've received, this is a really good example where we've actually done our job and done it very, very well.
Danny Kruger.
I don't think the honourable lady can say she's done her job very, very well if after presenting a bill after months and months of work and debate many hours debate at second reading, she suddenly decides that the bill is deficient in its central part. And if she talks about the opportunity for evidence that was taken and the opportunity for the committee to debate it, we haven't had evidence on this new element, on these new clauses, on the panel process. There were some vague suggestions that it might be appropriate made by some of the people we heard evidence from, but we had evidence on the High Court stage and the deficiencies therein. We have not had the opportunity to properly examine the panel element that's now being introduced.
Would you give way one more time?
With great pleasure.
Thank you for giving way, and I'll sit down. I won't take it too personally, things I've done a very poor job, but I think the point is we did hear evidence from a range of different professionals, legal experts, medical experts, psychiatrists, social workers, lots of different people. So I think we did have a broad range of evidence, and we also have had evidence coming in over the recent weeks and months which have added to that evidence, which have talked about these changes. So I think it is important to acknowledge that.
You mustn't apologise for intervening on me. I could hardly be one to object to people intervening. And I think this is a very good forum for the kind of exchanges we're having. So very happy to take interventions. And she's absolutely right. Of course, there's been lots of evidence presented. I'm citing it myself the whole time. Further evidence is coming in, and much of it very critical of the new proposals. So that's an absolutely fair point. But my point remains, we invited witnesses. We had 3 days of evidence on a bill which has now fundamentally changed I'd suggest the core safeguard that it contained. Well, it hasn't changed yet, but I suspect it's about to.
Will you give way?
Happy to give way.
I thank the honourable member for giving way, and I, as somebody who supported the bill at second reading on the basis of the High Court, but then read very closely, in particular, the evidence by Justice Mumby on the need for a strengthened evidentiary process so that this was not just a rubber stamping exercise, and secondly, that it would be better to replace the High Court with another system because of the role that it placed judges in. Having listened to 50 witnesses during that time, I am satisfied and I was persuaded through that process, a process which is a cross-party process which has led to an incredible example of deliberative decision-making. And would he not agree with me that this demonstrates the strength of this process in amending the bill where the evidence demonstrated that it must, and has enabled us to produce something that is much better and more in alignment with public opinion?
Well, I'm very grateful, and I greatly respect the position the Honourable Lady's come to, which she has been persuaded that this is an improvement on the bill, and I respect that. I recognise that's what the sponsor thinks, and others will too. But no, I'm afraid I don't accept that the process has been adequate. And I mean, she cites Justice Mumby and others who criticised the High Court proposals as they stood. I also have my criticisms of those. I think they were inadequate. The response to that is not to scrap them altogether; it's to strengthen them, as Justice Mumby suggested. And the Honourable Lady will know that Justice Mumby is not supportive of the new proposals either. He thinks they also fail the essential test that's required of being an effective safeguard. Nor does the new proposal, the panel, provide that opportunity for evidentiary investigation that would indeed be appropriate if we were to having a proper safeguard at this stage. So I respect her position, but I'm not persuaded. Happy to give way.
And those interventions, as I said at the start, should be short, not speeches.
Thank you, Chair. Thank the Honourable for giving way. He mentions that the way to proceed would have been to strengthen, through amendment, the existing High Court safeguard. I may have missed it, but I can't see amendments in his name that do that. So could he explain what strengthening of the High Court safeguard he would prefer to see rather than this?
I'm grateful, Chair. I'm about to come to that. I'm going to suggest how I think we could have done it better. So I take the Honourable Member's point, and that's indeed what we need to. I do need to answer that question. Happy to give
Okay,
that.
Just intrigued, he's talking a lot about the evidence. Was there any evidence on anything in the bill that changed his mind on any aspect of the bill?
Danny Brew?
Well, was there any evidence that changed my mind?
Why do you have a moment to think it is outside the scope of the bill, but you
Well,
carry on and think?
Thank you. I mean, I don't want to be facetious because I mean it's a serious point. But no, I mean there was lots of new points were made in the committee, including some in favour of the status of the bill as it is. Indeed, some of the new amendments which I've opposed in some cases. But no, I think we have had some very helpful evidence that has helped shore up the case made by the sponsor, as well as I think evidence that suggested otherwise. And some points in debate have been very well made. I was nearly floored by an intervention by the Honourable Lady yesterday, for instance. So there have been, I do respect the points that have been made both in committee and in the evidence. So my suggestion is that we should be doing this at report stage if we're doing it at all, because it reflects the seriousness of the proposal and the fact that the House voted for its second reading. There were problems with the High Court stage, as just been acknowledged, and others have referred to it in support of the change to these amendments, but I do want to quickly acknowledge, perhaps in response to my right honourable friend, points made by Lord Sumption, by Max Hill, by Alex Ruck-Keene, by Nicholas Mostyn, all senior barristers and judges. And it did become obvious that there were significant issues, particularly around the power of the court to investigate applications or to hear evidence on them, and about the capacity of the judicial system to cope with the demand. And it was clear that further thought was needed on the High Court stage. And indeed, it was apparent, Madam Chair, that further thought was indeed already underway. There's an interesting exchange in the record of the evidence sessions between the Honourable Member, the Justice Minister, and those witnesses, particularly Max Hill, who said that he was quite close to the construction of the bill. And that clearly shows that there already was thinking, in my view, there was thinking already underway behind the scenes that have led to these changes. But my view is that rather than ditching Clause 12, we should be seeking to make it work in ways that many honourable members have done. I'm afraid we just skipped over in the earlier groupings in this clause because there's no point, because we're obviously proceeding to the stand part debate and to eliminate the court altogether. There were things the committee could have set itself to address, but no, we haven't done that. The High Court stage was predicated on the campaign for the bill. That's the point I would make, and I hope you will excuse me, Chair, for making what might be a cynical observation. I think this High Court stage was recognised as popular and as useful to the campaign to get the bill through the House of Commons. And it was predicated specifically on the point, which is clearly communicated and I think understood by the public, is that this measure of assisted dying is intended for a very few people. It's for the most exceptional cases of people at the very end of their life, in desperate circumstances, in desperate pain and suffering indeed. Very few people need it. Whereas what the change will enable, and what I believe the change is predicated on, is that the real intent of the bill is for a far wider eligibility than just that tiny group. And I think we've seen through the rejection of a series of amendments that would have restricted eligibility specifically to that group that we all understand the case for an assisted death for, and who the public, again, supported in those specific cases, people at the very end of their life suffering intolerably. The bill is not, I will in a moment, the bill is not restricted to that group only, and that is why we need to widen, we need to redesign the system to enable this larger group to make use of it.
Thank you for giving way. He's been very generous with his time. I'm just interested in how he can conclude that the eligibility criteria have somehow been expanded by adding an expert panel with a psychiatrist and a social worker.
Danny Crew.
I'm sorry, I didn't intend to give that impression. That's not what I'm suggesting. What I'm suggesting is the rejection of a series of amendments that would have restricted eligibility or ensured that only the people who we all understand the reason for the case for assisted death for would be eligible, whether it's on burden or on pain or indeed the questions around capacity and coercion. Our amendments would have restricted, as it were, access to only to those most desperate people. And on that basis, it would have been appropriate, in my view, to have a High Court stage because the High Court could have accommodated this lower demand. Given the clear intent of the opportunity that the bill affords to a larger group of people to gain access to assisted death, it obviously has become necessary, I presume, in the mind of government and others, that there is insufficient capacity in the court system to accommodate the regime. that is being instituted here. So, I base this on the general observation. I think that the question of High Court capacity has been driven by the desire for a system that can cope with many thousands of deaths per year. And I've seen ranges suggested between 6,000 and 17,000 deaths per year. If honourable members have other calculations or estimates, I would be grateful to hear them. In fact, it would be good to know whether the government has done any estimation of what the numbers we're looking at are. If it was simply a case of averting those desperate cases of people who help their relatives to die by going to Switzerland or to assist them in committing suicide in other ways, we heard from Max Hill only a handful of cases cross his desk every year, so it's clearly an intention to greatly widen the scope just from that desperate group. But it's unclear what the actual overall number is, but my strong sense is that we are looking at many thousands. And for that reason, it has been decided that the High Court stage would not have the capacity to cope with it. Now, I certainly will.
Jacob?
I appreciate it. For fear of returning the favour in terms of implication of what the Honourable Gentleman is saying, but I think, again, we go back to an inconsistency argument here, to be quite perfectly honest, because on one hand we're saying we've got to have more psychiatrists, more social care and palliative care experts in the system, in the process. Now this has occurred, and now the Honourable Gentleman, in my view, is using that as a reason to say, well, actually, there's bad faith here, that actually the sponsors and proposers of the bill just want to widen it. I don't think the Honourable Gentleman can have it both ways, if I'm honest.
Yeah, I'm grateful. I'm not suggesting bad faith here. I think there's a genuine view, and it might well come from government's own official advice, that the bill as drafted and as amended will allow many thousands of people to gain access to assisted death every year. And on that basis, we are going to have a system that can cope with them. And the judiciary clearly communicated it could not cope. And I understand why they would do so. So, yeah.
I appreciate that, but I think just this morning we heard from your colleague, the Honourable Jensen's colleague sitting next to him, that actually because there's not enough people in this system, because there's not enough psychiatrists, or because there's not enough social care workers, that this panel isn't workable either. So again, I think there's an inconsistency here. There's either enough capacity in this system, or there's not. So which one is it?
I'm sorry to disappoint you, Honourable Member. I'm afraid I'm going to have it both ways. I think this bill is profoundly flawed. And particularly if we're going to have large numbers of people going through it. And whether they go through a judicial system or a panel system, there's going to be huge capacity constraints on the professionals involved. And we've transferred that responsibility and that problem from the judiciary to psychiatry and social work. And unless, of course, it's a rubber stamp exercise, which I fear it might be too. But even then, you're still involving psychiatrists and social workers in a rubber stamp exercise. I certainly shall, yes. So, yeah, no, it's quite okay.
I appreciate it. But I think then that kind of demolishes your central argument that you're making here. If on one hand you're saying, well, actually, we're going to be expanding it, but you've just said that actually this panel system won't be able to expand it. So if the motive of the proposal of the bill is to expand the system, as you say, in terms of more people being eligible, but you've just literally said, the Honourable Gentleman has just literally said, well, actually, these constraints of the panel won't mean that. That will mean that doesn't happen anyway. So, again, I just think you're conflating different things and being totally... the Honourable Gentleman being totally inconsistent here, if I may.
Okay. All right, well, I regret my failure to assuage the anxieties of the Honourable Member. Understood. Okay, so let me explain some of the challenges that we've got with... or rather, why it was so important that we did have a judicial stage. And my complaints against it were never against the principle, but always against the practicalities for reasons I've just given, and I'll go on to say more about. But the value of a judicial stage is that it gave the doctors certainty and indeed protection for the process that they were responsible for. And I want to cite the evidence from the Medical Defence Union, which is it's essentially the union for doctors. It provides them with insurance against claims of medical negligence. And their point is, and I quote, they're responding to the suggestion that judicial involvement could be replaced by some other decision-making body. They say, the MDU strongly rejects this assertion. The involvement of the judiciary is essential. Its absence leaves doctors unduly exposed. Media reports suggest an alternative safeguards being mooted. No independent panel, they say, however so constituted, can replace the legal authority of a course of action sealed and ratified by a judge. Doctors deserve that certainty when relying upon this bill to provide the very best for their patients at the most delicate moment of their duty of care. And I also want to quickly cite the evidence we received from Ruth Hughes, who is a barrister with 17 years of experience in the mental capacity law. I couldn't say she's KC because she doesn't become a KC until later this month, and congratulations to her. But she's a senior barrister, and she said this in her written evidence, that there is no judicial declaration because the judicial safeguard is not enacted. Sorry, if the judicial safeguard is not enacted, there is a risk that the estates of persons who have been assisted to die will be sentenced to turmoil. So talking about their estates, their will. This is due to the possibility of arguments being made that beneficiaries of the estate have influenced the person into obtaining the assisted death. Even if there is no conviction, but another person asserts there was influence, not undue influence, certainly not coercion as is banned by the bill, but a lower standard of influence by a beneficiary of the estate, then the personal representatives will be advised to obtain direction from the court as to how to administer the estate. So the point she's making is that there is, even if the bar for the assisted death is met, in terms of influence and coercion and so on, as it were, testamentary or probate challenges that the states will then go into will be considerable. So the fact is, and just again to cite the Medical Defence Union, the fact is somebody has to be the judge. Somebody has to take full responsibility, legal responsibility, for the decision that's made. And in a common law system, we don't give powers of life and death to panels. We give them to legally constituted bodies with judicial authority. And to cite the MDU again, I quote, "To put it plainly, without judicial involvement, someone will have to take responsibility for the legality of the action." Happy to give way.
Dr. Simonow.
Again, thank you for quoting all this, but does that mean you support the original Clause 12?
I'll be voting. Thank you. I'll be voting for Clause 12 to stand part because I think it is an essential safeguard. It's not strong enough. There were all sorts of problems with it around capacity and the way it's constituted. And I'll come on now to how I think it could be improved. No, the honourable gentleman doesn't seem impressed by my straight answer to his straight question. Yes, I do support Clause 12. I think we should strengthen it in ways I'm now going to explain. We do need a court, and I think Parliament was right to demand this or to support it. We have a comparable model in the Court of Protection, as happens when there are disputed decisions about whether to withdraw life support. By the way, I would mention to honourable members who have referred to this before, in the Court of Protection, one is obliged to notify the family, just going back to a debate on an earlier group. So even there, when there's a decision to withdraw life support, the family is notified, but we've decided not to notify the family through this bill. But anyway, the Court of Protection does give us an appropriate comparison here. Whether it's the Court of Protection or the High Court, either would work if the system was set up right. And the crucial thing, in my view, is that it does need a proper adversarial arrangement so that the judge can actually judge. The way the judges work in this country under the common law system is that they hear arguments and they make decisions. And it's been suggested that there could be a role for the official solicitor in acting, as it were, for the state, or indeed for society, perhaps, however we want to put it, to perform the role of challenging the application and putting, if there are alternative pieces of information that the judge should consider, taking responsibility for presenting that. Happy to give way.
I'm grateful for the honourable gentleman giving way, and again, I don't want to imply anything that the honourable gentleman may be saying. But am I correct in hearing, therefore, that in an adversarial position which you're supporting, is that essentially a person coming to the end of their life who've gone through this process will have to essentially argue their case in front of a judge?
No, thank you. No, I don't think it's necessary for the applicant themselves to come to court and to present their case. That might be completely impossible or inappropriate. But there does need to be a case made to the judge about why it should proceed, which is indeed the original proposal, and indeed it'll be the proposal under the panel system as well. The case is made, should this go ahead. My suggestion is that there needs to be representatives of the applicant. They may want to appear themselves, but there also needs to be somebody who's putting the other side of the story. Maybe this isn't the right thing to do. Has the court, the judge, considered these parts of the evidence? Have they considered this aspect of the report from the assessing doctors? And that would be an appropriate procedure, completely consistent with how these important decisions are taken in other aspects of our system. Yeah.
Jack Abbott.
I'm grateful for the Honourable Gentleman giving way, again, to myself. But I think there is a difference between an adversarial system and an inquisitorial system, which is what I believe this panel to be proposing. So under this panel, it's not an adversarial, it is an inquisitive position. And I don't think it's a million miles away from what the Honourable Gentleman's saying, but I do think there is a distinct difference. And if the Honourable Gentleman's arguing for an adversarial position for the panel, that's a very different one to where the panel actually currently is.
Yes, I think it would be inappropriate to ask a panel to operate in an adversarial system. It would be inappropriate to ask a psychiatrist and a social worker to act as a judge. What we need to do is to have a proper court system in the way we always do with other important decisions, in which two sides make arguments. Let me try and explain. I mean, I agree that what is being proposed is an inquisitorial system through a panel, completely alien to the British common law model of making important decisions. But that is what is being suggested. I don't think it's appropriate. What we should have, and if honourable members want to know, I don't believe in assisted dying. I think it's the wrong thing to do. But if we were to do it, and actually I sort of feel that this is where we've got to through these debates, and if only this debate had happened properly prior to the bill being drafted, I think something more like this system might have been proposed, which is that we have a proper multidisciplinary team at the outset. Perhaps a doctor does the first declaration, as proposed, but we then go into a proper multidisciplinary team. Not just the options to refer to psychiatrists if appropriate, or to maybe consult a palliative care specialist. All the appropriate specialists that should be involved in assessing capacity, coercion, making clear the alternatives that the patient has, making proper diagnosis, hearing from family members, all of the appropriate process that should be followed in a case like this. That should happen at the very beginning of the process. There's no need for a lawyer at that stage, in my view, on this multidisciplinary team that we've created at the end of the process. It would be a proper professional combination of clinical and social work professionals. Their reports would then feed into the judicial process, which would be the second or third stage if we have a doctor at the very beginning. The judge would then hear arguments from, as it were, both sides. That needn't be a distressing, it needn't be a time-consuming process, but it would be an appropriate one under British law to make decisions of life and death. And that court would hear clearly arguments made by both sides. Happy to give way.
So, just so I'm clear, the Honourable Gentleman envisages that I would either be in the hearing or lying in my bed listening to the hearing, the fungating tumours in my neck, right, restricting my ability to breathe, having gone through all the eligibility, and I have to sit and listen to someone argue that I should go through a death that I'm trying to avoid, and that I don't have capacity, or that doesn't the Honourable Gentleman see that could be profoundly distressing to someone who is in the closing moments of their life, and in many ways might actually be cruel and traumatic for that person to have somebody frankly argue that I should endure the pain in their opinion.
I regret my right honourable friend making that argument. The fact is already the panel is going to be considering whether it's appropriate. There might not be some professional who's there with the purpose of maybe suggesting that there are other things that the panel should consider. But the patient's already lying there, waiting for powerful people in another room to make a decision about whether they're going to get an assisted suicide or not. So that process is already going on. And to his question that it's intolerable for somebody to be making the cases against their assisted death, I put to him an alternative hypothesis, not somebody in the situation he's in, but the victim of years of coercive control, a person with undiagnosed mental health conditions, somebody who is feeling a burden on their family, whose relatives want their money, none of which has yet been fully identified through the process of the doctor's stage of the initial doctor, and been commented on in some of the evidence that the multidisciplinary team heard. They, I hope, might think if somebody is there making the case for them, as might their family, it is totally appropriate for a court to hear perhaps that this procedure should not go ahead because of these other factors, which only now are being properly understood by the decision maker, who is doing so openly, not in a private session, not a decision being made by people who are themselves committed to the procedure and the process of assisted suicide, but an independent judge sitting in their judicial capacity in open court with all of the safeguards and accountability that the judicial system has. That feels to me like a perfectly appropriate safeguard, and I think, I suggest, Madam Chair, in principle, it's what the House of Commons thought they were getting when they supported this. Happy to give way.
I'm grateful to the honourable gentleman for giving way, and I'm just reflecting on the intervention from the member for North East Hampshire. Would the honourable gentleman not agree with me that what the purpose, either of the panel or of the High Court judge, is to establish beyond all doubt that if a person is assisted in their death, that no crime is being committed, and that in order to establish that a crime isn't being committed, you do need to apply the highest standards of evidence. Now, whether it's an adversarial or an inquisitorial to collect that evidence, and so therefore there has to be some kind of process, which may well be uncomfortable for the patient themselves, but is necessary for their friends, their relatives, and the doctors being asked to assist. And that really is what we're trying to achieve.
I'm very, very grateful to my honourable friend. He makes an absolutely central point, which is this is a judicial process. There is a decision being made, and I recognise that the honourable lady has abandoned the claim that this is a judge-led process, correctly, because it's not. But the function of this panel will be essentially judicial, and not least because the decision to proceed with the assisted death entails the people involved in administering it being exempt from the criminal law, from not being liable to prosecution under the Suicide Act. So we have made an exemption for what is otherwise a crime. And if they don't get the go-ahead from this panel, they will be committing a crime if they go ahead. So it is, in all essence, a judicial decision that is being made. And it's quite right that we have the protections of a court. Now, a couple of brief points about the practicalities, and they've been made partly by others. But the central point to make is that we don't know whether the professionals that are going to be required to take part in this panel do have the capacity. Now, we know that the judges don't have the capacity under the current design of the law, which is an essential flaw, or we think they don't, because that point has been very comprehensively argued by the judiciary, and I suspect by officials at the Ministry of Justice. But what we don't know is whether the psychiatry profession and the social work profession has adequate capacity, and there's been no impact assessment. We've had a lot of comments from representative bodies expressing anxiety about the capacity of these professions to supply the panels. But the point I'm trying to make, Madam Chair, is that we cannot and should not legislate in the dark. We should not draft laws in ignorance of these basic points of fact. We need to know whether a law before us is workable in the real world, and I'd be grateful for clarification from ministers when they come to speak to this clause. In my view, we need robust and clear data on how many professionals might take up the posts, and more importantly, we need the clearest and earliest warning of where there might be deficits that would compromise the entire system, particularly around the capacity of psychiatrists. So I do think we have a central problem with ignorance around capacity, but my strong view is we do have a problem with capacity. Just another quick point to make. It's been discussed in early stages of the debate in the committee, but an important point. It was made by Alex Ruck-Keene in evidence to us around the judge-led process. A point that he made is that it would not be possible for the judge to decline an assisted death on the basis of what he called service denial, i.e. there is not enough treatment available, social care treatment, for the patient, or indeed medical treatment. So if the reason that the patient was seeking an assisted death were because the local authority would not provide them with the improvements to their home, or the funding, or they couldn't get the medical treatment that they wanted early enough, that would be a legitimate reason, or would not be a reason not to proceed with an assisted death. And that feels of very grave concern to us, and it's what happens in other countries when, and we heard evidence from it already this morning, of when a patient is denied medical or social care that they need to carry on living and to live well, but they are offered an assisted death. In those circumstances, I would really hope that the decision maker will conclude it's wrong that we offer assisted death. We need to, in fact, insist that they get the support they need to live well. And the point I reference it simply because in the new clauses, there again, as I understand it, no opportunity for the panel to decline an assisted death on grounds that it's only being sought because of the inadequacy of the wider care system. It's also been suggested that, that the judicial option does remain through the judicial review system, and other members have responded to this point, so I won't labour it. I just wanted to quickly make the point that new clause 17 actually makes judicial review less likely because it does often offer the opportunity for a sort of an appeal, obviously an appeal only in one direction against refusal, but there is a sort of an appeal process in the system. And as my honourable friend here said earlier, if there is a JR, it is likely to take a long time. There's no question about whether legal aid will be arranged. You know, the state's proposed to pay for people to go through the assisted dying process. It's not going to be prepared to pay anybody to challenge it. So they'd have to raise their own money, and it would take a long time. Whereas it would just be so much simpler and better to, whether it's a panel or a judge, to set that system up in a way that allows both sides to be told, and then not have to rely on a cumbersome judicial review system. Now, Madam Chair, let me reiterate that I do support the multidisciplinary team. I think it's a very good thing that the sponsor has decided to introduce a proper stage at which a psychiatrist and a social worker will have to consider the application properly. I have concerns about how it would actually work, which I'll come on to, but I think it is the right system in principle to have a multidisciplinary team. I do want to stress that the professionals who made the case for multidisciplinary teams as part of the assessment process have not endorsed the new clauses. They're not saying that we have adequately met their concerns about the process.
What do you agree on that point?
Happy to.
I'm not entirely sure who he's referring to, but I think it's fair to say there are a range of different views across a range of different professions, and I think it's important to acknowledge that.
I do apologise. She's absolutely right. Of course, there are, I'm not sure which, but no doubt there are representative bodies of the different, whether that's patients' groups or the professionals representing, or the bodies representing the professionals who are satisfied with the new proposal. I don't know which they are. I mean, genuinely, I just haven't come across them, but I'm no doubt there are some. But happy to hear. Yes, thank you.
Well, I think just to clarify on that point, the point I'm making is there's a range of different views across a range of different organisations, many of whom are actually neutral on the issue of assisted dying, full stop. But also within each profession, there are a range of different views as well. And certainly from the evidence we heard, we had people working in palliative care with different views, we had medical people with different views, and I think it's really important to acknowledge that.
Danny?
Yes, I mean, a number are neutral. I'd be grateful if she could tell the committee if there are any representative bodies working with the professionals who administer end-of-life care who have endorsed either the bill as it was or the bill as it is. I don't believe there are. The Honourable Lady is going to check. My understanding is that all of the bodies that represent palliative care professionals and end-of-life specialists are opposed to the bill as it was and as it is. And I think there are straightforward reasons for that. But everybody agrees that there is value in the multidisciplinary team approach. And the Association of Social Workers, they provided evidence setting out what they thought was needed. And what they thought was needed is an MDT working at the assessment stage. This is not that. And I do want to stress, Madam Chair, I think it is very important that we do not confuse the provisions made under the new clauses here with a multidisciplinary team operating at the appropriate moment in the process. I think we have to have public confidence in this process. It is very important that the composition of the new proposed panels is not conflated with the separate matter of a multidisciplinary team model. It would be very unfortunate if this confusion obtained. The bill, as drafted, rejects the involvement of a multi-professional team model for the conduct of the assessments, preferring two doctors working alone without input from a multidisciplinary team. I recognise there are opportunities for them to hear from other professionals, but it is not a multidisciplinary team in any recognisable sense of the term. And it is not. And I will in one moment. For a moment, I was going to finish by saying it's not correct or accurate to give the impression either that Dr. Cox or the Association of Palliative Care Medicine support the approach that is being proposed. Happy to give way.
Yeah, I thank him for giving way. And it is really important to be clear about this. I don't think anyone is suggesting that what is in the bill replaces existing good practice. And I think this is a really important, we probably all have got family and friends who have been treated for cancer now, and they are looked after and cared for by a multidisciplinary team. That team doesn't suddenly disappear and is replaced by this. That can continue. What we have then is this assisted dying option, which involves the 2 doctors, and I would struggle to envisage any situation where they wouldn't work with that multidisciplinary team and add on, where appropriate and necessary, psychiatric intervention, social care, healthcare professionals. So I don't think these 2 things operate independently. That's the point I would always come back to.
I'm grateful. She does always come back to that point, and I do respect it. She imagines that the good practice which is prevalent in the system will obtain automatically in all cases under the assisting dying regime, even though that regime is completely new. And she says she can't envisage a scenario in which the doctors would not hear from all of the professionals who we would all think should be consulted at this stage. 2 points to that. One is, well, why not make it explicit that that is required? And second, I'm afraid I can envisage scenarios in which doctors, some years down the line perhaps, once this model of death has become normalised as it has in Canada and elsewhere, with up to 10% of deaths being done through assisted dying, it just becomes a procedure. And we haven't ruled out the possibility, the likelihood, in fact, of independent clinics establishing themselves with a business that is about providing the support for people who want to end their life. And there will be doctors who are very happy to conduct the assessments, to take at face value what they hear from the patient, not to involve a wider multidisciplinary team in their consultations, and expedite the process as the bill, as drafted and as amended, allows. So I'm afraid I do foresee a scenario in which the good practice that we all believe in does not happen. And my concern, and I expect hers to be the same, would be to prevent that from happening. Happy to give way.
I thank my honourable friend for giving way, and I think he's making a powerful point. And one of the concerns I have is what happens if someone is seeking assisted dying privately through a clinic. I see risks there in terms of multidisciplinary teams involving social workers still continuing in that instance. Does my honourable friend share my concern?
He certainly does. I'm grateful. Yes, I do, and that is exactly the scenario that I fear. I fear it within the NHS too. Let us not imagine that every NHS doctor has all the time and the access to the wider specialisms that they would wish for. And there will be a very strong incentive under the current bill and a very strong personal instinct, compassionate doctors believing in the autonomy of patients, respecting the patient's wishes, to take at face value what they are told, and not to seek the expertise that would happen automatically if there were a proper multidisciplinary team at this stage. So, Madam Chair, my point here is simply that we do need a multidisciplinary team, but this isn't it. At best, it's half a multidisciplinary team. There's no doctor on it, actually. There's a lawyer, pointlessly, a sort of quasi-MDT, a sort of duodisciplinary team is what we've got. But it's in the wrong place, and it's not assessing, which is the job it should do, it is judging. It's not diagnosing or advising in a way that a clinician should do. It's simply deciding whether the criteria have been met for an assisted death. And this job was rightly given to judges in the bill that the House of Commons voted for. But this bill has neither the powers, nor the safeguards, nor the accountability, nor the independence of a tribunal, let alone of a court. And as the Honourable Lady has candidly said, it's not a judicial entity in any sense. It's a weird creature, neither one thing nor the other, a quasi-multidisciplinary team at the wrong stage in the process for the wrong purpose. I've said it's not a multidisciplinary team. It's not really a judicial entity either, as the Honourable Lady has mentioned. It's certainly not a judge plus, as was originally suggested. There's no judge, just a legal member, not a judicial member, a legal member who might be a lawyer. Happy to give way.
There is a judge. There's a judge. It may be a retired judge who is the commissioner, who heads up the entire Assisted Dying Commission. And there is a legal expert on the panel as well. As he said, that could indeed be a judge. It could a retired judge. So there is legal expertise there. And also, I think he made the point that there isn't a doctor on the panel. My understanding is that psychiatrists are doctors. If I stand corrected, if that's not true.
So he's absolutely right. I do apologise. There is indeed a doctor. There's a psychiatrist, but there's not a doctor specific to their condition.
No, we've had 2 of them.
Indeed. Well, no, we've had a couple of GPs is what we've had. We haven't had a doctor specialist in their condition. If needed, there's the opportunity to refer to. It is perfectly possible that this whole process of an assisted death could be done very well under this bill.
Good.
So isn't that good news? However, there's also a very great risk that it won't be done well. And there are huge gaps through which bad practice can creep. And my concern is, specifically to this stage, that we don't have the appropriate expertise on this panel. And to her point that it might be there is a judge in the process, well, there is a distant judge who sits above a quango, which appoints the panels, not only taking in a view on a specific case if there's an appeal against a refusal. So not directly judging on the case, as the House of Commons was told would happen. Yes, happy to give way.
Kim Ledbetter.
The reports for the case would go to the Commissioner, so he would see the reports, or she.
Yes, but he or she will only consider a reconsideration on the basis of an application to reconsider made by the applicant. So there is only one opportunity for an appeal that can only happen in one direction,
Yes.
against a refusal. So that's the role of the. I'll come on to the role of the Commissioner in a moment, but the suggestion that there's a judge involved in the decision, in the great majority of cases, will not happen at all. There might be a retired judge on the panel, but it's extremely unlikely that would happen. More likely there'll be a lawyer. Again, in a sense, I mean, it's appropriate to have some sort of it's a judicial exercise that's being conducted. I think it should be a judge sitting properly in a court. Happy to give way.
I thank the Honourable Member for giving way. But does he also share my concern that, unlike the Mental Health Tribunal, the panel does not have, is unable to, doesn't say anywhere in the bill that they can actually call people and ask them to swear under oath like you can in a mental health tribunal?
I'm very grateful. She's absolutely right. So, having said it's not a proper multidisciplinary team, I agree very much with the Honourable Lady that it's not a proper judicial entity either. It's a panel with judicial power to approve life or death decisions, but without a judge or the normal judicial processes that would happen in a tribunal or a court. So there's no oath being taken either by members of the panel or by witnesses to it. There's no independent appointment process of the members of the panel. They'll be appointed by this commissioner. There's no power to order the disclosure of information to the panel. There's no power to investigate wills or financial records or anything like that. There's no requirement to meet the doctors or indeed even to hear or even to discuss with the patient themselves if they consider that to be appropriate. And there is no appeal against an approval, just a one-way appeal against a refusal. And the appeal goes not to an independent judge sitting in court, but to a commissioner, an appointee of the government, the person who's been set up to facilitate the whole system. So let me come to this role, the VAD commissioner, as somebody called it, VADA, as I think of the role, the VADA. I won't labour that poor joke. The VAD commissioner, they can be a sitting judge, and that's good. But I want to just suggest to the committee, be interested in the minister's view on this. It's highly unusual that sitting judges can be appointed to other public functions that are unrelated to a judicial role. So sitting on the, they can be appointed in a second role job that is itself judicial, chairing the sentencing council, that sort of thing. But I'm not aware of other examples or many examples of where a sitting judge sits in a non-judicial function. I've looked into this and I discovered that there are in fact 3 exceptions to this rule. The first is that the Master of the Rolls holds for a number of sinecures relating to the keeping of the public archives and the payment of the national debt. So that's a non-judicial function that a judge carries. The chair of the Law Commission is a sitting High Court or Court of Appeal judge. And exceptionally, with permission of the senior judiciary, sitting judges can be asked to conduct public inquiries. So a singular public inquiry, which is in itself judicial in its purpose and is time limited, and is essentially judicial in trying to determine what happens, and will of course operate in an adversarial way with hearing proper evidence from counsel. That is the only exception, but that is not comparable to the model that's being set out here, whereby a sitting judge is being asked to chair a permanent quango, a government body. Happy to give way.
Would he agree with me that that's exactly the point? This is a unique situation, and therefore we do need a unique system, and that is the perfect opportunity to use the skills that a judge or retired judge has.
Well, I mean, the Honourable Lady and others have frequently made the case throughout this debate that we should be sticking with the existing system, so, you know, the Mental Capacity Act, the use of doctors to determine decisions about healthcare. But now, the opposite point is being made, that we have a unique system and therefore we need to tear up the current way of working. Actually, in this one case, I think we need to stick with the way of working, which is the British judiciary. The High Court of England is the appropriate body that can make decisions about life and death, which is indeed how it does work in other major decisions of life and death. These are questions that go to court. Now, the point about the VAD Commissioner being a sitting judge, even when it comes to inquiries, which judges do conduct outside their role as judges, sitting judges in court. My understanding is that the executive doesn't pick whichever sitting judge they want for that role, but instead they request that the Lady Chief Justice makes a judge available, and the Lady Chief Justice will select who the appointee is. Whereas what's proposed here is for the Prime Minister to pick from the bench of judges his or her preferred candidate. So, again, this feels like the use of a judge simply to fulfill a role that frankly does not need to be carried out by a judge when we look at the functions that this commissioner is going to have. Just to emphasise for clarity, I'm very in favour of judges deciding on cases. I don't see why a judge should fulfil the role of sort of chief quangocrat for the administration of the regime. It's quite right, in my view, that previously, and under the previous version of the bill, most of these functions were given to the chief medical officer, because most of the functions that are required are essentially to do with the administration of the medical aspects of the bill. The collection of data, the monitoring the operation of the Act, that is best left to a medic with experience of our healthcare system, rather than to a judge. These are not judicial functions. Now, the only function which is carried out by the Commissioner, which requires one to be a judge, or which is in a sense judicial, is the review of the panel decisions, which I mentioned, because here a judicial decision is being made. As I mentioned earlier, under New Clause 17, subsection 2, the test for this is limited to an error of law, irrationality or procedural unfairness. These are the grounds of judicial review, and the point I'd make there is that if we didn't have New Clause 17, the ability to judicially review panel decisions would still remain. It could be argued that New Clause 17 actually limits judicial review by only allowing a person concerned to apply for reconsideration. Now, I understand that some courts in Canada, which has a comparable judicial system to ours, common law system, have held that family members do not have standing to judicially review decisions to authorise medical assistance in dying. So the suggestion that's been made that families who are concerned that an error has been made in a decision to approve a death should be able to quickly get an injunction through a JR. Well, I hope that is the case if we come to this, if this law passes as proposed. But it's certainly not the experience elsewhere, and I fear it might not be the experience here. So all in all, to conclude, Madam Chair, I'm afraid we have a dog's breakfast of a system. All the problems of the High Court system that have been aired without any of the benefits. And I want to finish by quoting Sir James Mumby. I know he's been cited regularly. But the Honourable Lady did say yesterday that, having listened to Sir James, she set herself the task of designing a system that would satisfy a former President of the Family Division. And I'm afraid to say she has not succeeded in her task. And he has said, quote quickly a few points that he said in response to the proposals of the new clauses. The process is simply not apt to enable the panel to perform its function. He says the panel is given an extraordinary degree of discretion in relation to the process it is to adopt. Unprecedented. He has suggested that the panel is, as quoted before, the panel is little more than a rubber stamp providing a veneer of judicial approbation. I don't think rubber stamps provide veneers, but I won't challenge his point is well made, and I respect it. He said that's fundamentally unacceptable. And he says, if the panel, to quote finally, if the panel is to perform its function effectively and do more than just check the paperwork, if it is to be the real safeguard intended by its proponents, then its processes must be much more thorough than is currently proposed. All in all, in relation to the involvement of the panel in the process, the bill still falls lamentably short of providing adequate... happy to give way.
I just think it is very important to point out, and we have, many of us have quoted Sir James Mumby, for whom, again, I've said I've got a huge amount of respect, but there are a number of other views from ex-judges and from very highly regarded legal professionals, which conflict with what Sir James says.
Danny?
Thank you. I think it would be very helpful if the Honourable Lady could, not now, and it doesn't need to be in the course of these deliberations, but could publish the evidence of that assertion. Which senior judicial figures have endorsed the new plan? I think it would be very helpful to hear from them. We heard many criticisms of the previous regime. Many of the people who set out those objections, which, in my view, I think it's the case, prompted the change of heart that these new clauses derive from. And the weight of evidence that I have seen is that we still have many of the same problems to do with that the High Court has, a lack of effective powers, questions around capacity. We also have a whole load of new problems to do with the essential illegitimacy of a quasi-medical panel of people making an essentially judicial decision without the opportunity to hear in a meaningful way from all of the different stakeholders that should be consulted. Happy to give way.
I just want to understand and clarify. He said earlier the Commissioner is sitting as a judge, but my understanding is that the Commissioner is not sitting as a judge. And I don't know what he meant by that.
I'm grateful to her, and I think it was the Honourable Lady, the sponsor, who said yesterday that we had to grapple with this confusion, which is that it is a judge not sitting as a judge. It's slightly like a minister not sitting as a minister, where this bill has provided all sorts of interesting hybrid creations of people who inhabit split personalities and dual roles. But the Honourable Lady is absolutely right, I think, from the evidence we've heard from the sponsor, which is that while they will be a judge, which satisfies the cosmetic need to present this as some sort of continuation of the High Court stage which the House of Commons voted for, they will actually not sit as a judge. It's rather like they're being, having a hobby or a spare second job. I'm not sure judges do that, but chairing a football club on the side or something. They have this. Their status derives from their judicial role, but they themselves are sitting as the Commissioner in a sort of lay capacity. I think that's right. Happy to give way.
Just on that point, I think we've already talked about, I think he himself said, public inquiries. It's a very similar situation. We have a judge who is sitting there because of their skill set and because of who they are, not necessarily in a traditional judicial capacity.
Well, it'd be interesting to hear from the Minister, who's better, but more equipped than the rest of us to opine on this. I mean, my understanding is that a judge sitting as the chair of a judicial inquiry might not be sitting in court, but they are there, and they are there because they are a judge. They are there, and their function as the chair of the inquiry is essentially judicial. So I think there is that is the only example, the only comparison, and it is essentially different because the exercise of a public inquiry is time limited, and it is specific to a particular case, which is to determine the truth or otherwise of what happened in whatever situation it's being asked to inquire into. What we're setting up here, though, is a quango, an arm's-length body of government that will sit in perpetuity and will oversee a bureaucracy of state. And that is something that no judge does in our system, and in my view would be completely inappropriate for a sitting judge to do, even if we could find a sitting judge who would be prepared to fulfil that function, which I think might be challenging. And as I said, lastly, the other key difference is to evidence the point that a judge chairing a public inquiry is essentially judicial in their appointment and their work. They are appointed by the Lady Chief Justice. The judiciary appoints one of its own to fulfil a judicial function as the chair of an inquiry. What's being proposed here is that the government, the executive, not the judiciary, appoints the chair of the commission from the bench of judges. Happy to give way again.
Now, Sean.
I thank the Honourable Gentleman for giving way. I think just listening to him then, it creates another concern for me, and I wonder whether he might be able to speak to it. In terms of if we do have a judge, whichever way that is, and if they are sitting in that capacity, if it's an expectation of them to be in a judicial capacity, then does that not raise concerns that an appeal is allowed one way if you're refused an assisted death, but appeal is not allowed in the other way, which is that you want to appeal against an assisted death? So by definition, that position becomes compromised, or does it not?
I'm afraid that's absolutely right. There is an essential problem with the role of the Commissioner as the backstop, as it were, the Court of Appeal for what are effectively judicial decisions that have been made by this non-judicial panel. And the fact that only appeals can be heard against a refusal, not against a approval, confuses the whole question of appeal and judicial review. It's plainly unjust, and it does indeed compromise the idea that this judicial figure has the independence that a judge should properly have. So I agree with the Honourable Lady. I think I've concluded, Madam Chair. Thank you.
Now, Sean.
Thank you, Chair. And I wanted to move and speak to Amendment NS2C, tabled by the Honourable Member for Lowestoft. This amendment requires members of a panel to have undertaken training in respect of domestic abuse, including coercive control and financial abuse. Chair, this extends the principle of Amendments 20, 21 and 22, also tabled in the name of the Honourable Member for Lowestoft, which requires the medical practitioners involved in the assisted dying process to have undertaken similar training. I'm happy to give way if a sponsor of a bill, because I'm really pleased that in the previous amendments has accepted this amendment, and I don't know if she wants to indicate whether she's going to or not in this instance.
Should she give way?
Yes, happy to.
Kim Ledbetter.
Yeah, I mean, there is a strong argument which people have made to me that actually the professionals that we're talking about on the panel would have the skills and the training in order to fulfil their role, but I think it is important, particularly given the length of time we've spent discussing this issue, that they do have that same training, so I am happy to support that amendment.
Now,
Thank you. I appreciate my honourable friend's intervention, and I'm pleased she's extended that to this role. Nonetheless, I will just speak briefly to the amendment itself, because I do still have some concerns about, yes, it's an absolute necessary safeguard, and I really welcome the fact that it is being accepted. However, what it doesn't do was, it doesn't, I'm pleased it's extended to panel members, but what it does still doesn't meet the safeguard needs when it comes to people of ethnic minority background, coercion, cultural competence, etc. Because we know that people have, organisations have raised concerns about it. The truth is, Chair, this bill is very, very gendered. The analysis by women's organisations of half has found that if this bill passes and trends follow that of Australia, 1.65% of all deaths in this country could be via assisted dying, and if so, as many as 1,400 domestic abuse victims could die each year through that process. So it's vital that members on all sides of the debate we're conscious of the fact we are opening up a new avenue for domestic abuse with this bill, and that's what this amendment speaks to. But again, I won't go over, it saved me time and the committee time going over the details, simply because we've already gone over this in the previous three amendments. On that point, I'll finish, Chair. I do have there's any more speakers? Yeah, sorry.
Kit Malthouse.
Madam Chair, I just wanted to arrive briefly, and it is briefly largely down to the excellent speech of the Honourable Gentleman from Rother Valley and from the Honourable Gentleman from Ipswich, just to amplify a couple of points. First of all, just in clarification, I understand there are situations where judges can sit in essentially supervisory positions, not least, for example, on the BBC board, and they can, of course, be crossbenchers in the House of Lords. There are other charitable trustee roles that they're allowed to undertake, albeit that they are restricted in their activities. I just wanted to say a couple... Yeah.
Yeah, I think this is important. Those roles are there, what they do in their spare time. I mean, I suggested they can chair a football club or something as well. The point is that they're being asked here to fulfil a function on behalf of government, in their working hours, and explicitly to do so because they are a judge, and yet they're not sitting as a judge. Surely he acknowledges that this is essentially unprecedented.
No, I don't acknowledge that at all. I think there are, we've over the years we've used judges, started to use judges relatively flexibly. Even, for example, for non-statutory inquiries. I mean, he only refers to statutory inquiries. So much the better. I mean, I'm not a lawyer myself, but I believe in the rule of law, and so the more judges there are opining on our freedoms or otherwise is good, I think, generally for the country. I wanted just to amplify a couple of points, though. At second reading, I made the case for the High Court to be involved, and I agree with the Honourable Gentleman. At that stage, I was very happy for there to be effectively a scrutiny and authorisation third layer to the bill. My understanding of judicial opinion was that actually, certainly Lord Sumption's view was that level was unnecessary. And actually, I think he referred to it being a profoundly intimate conversation that really should just be between the patient and the doctor. However, I think the Honourable Gentleman is right that the weight of moment in the House and the weight of opinion was that there should be this third layer of scrutiny and opinion. And I also dismissed the argument about the capacity of the judiciary to absorb the argument. And I do fear that if we start to accept that argument, that we go down a very difficult road for Parliament. Not least, for example, we should have been opposing the bill that went through the House last night because of the greater imposition it will put. We had the crime and policing bill, probably many we went through without a vote, that will impose new burdens on the judiciary and indeed the police, as will the new offence of spiking. No doubt the Immigration Act that's coming through will put significant extra burdens on the police and the courts. So there are two separate questions here. One is what Parliament does. The other is the capacity of the public sector to absorb it. The answer to that is not to say, well, I'm afraid all you people have to go through a death you don't want to go through, because it is to say we haven't got enough judges, right? And to recruit more judges if that is required. Now, in a moment, my personal view, it's not. At the time, my view was that if I'm a footballer and I can show up in the middle of the night and get an injunction to stop the Daily Mirror publishing unpleasant stories about me, then I should be able to find, the judges should be able to find time in their schedule to accommodate the requirements of my death.
I'm grateful. Of course, it's absolutely right. If Parliament decides that we should proceed with this, then we should proceed with it, and the public sector will be obliged to make accommodation and provide the resources necessary. Does he agree with me, though, on that basis it would be appropriate for government to have clarified by this stage what the resource requirements of the new system would be, to make clear that there is indeed the capacity in the system to do that? And does he share my regret that that hasn't been done?
No, I don't share that regret, because until today, and until we all vote on it, they don't actually know what they're facing. And the government has undertaken that it will produce exactly the assessment that he's talking about between the end of this process and report stage, so we can all have a look at what it's going to be. Now, at that point, members can put a price on other people's death and other people's pain if they want to. But there are lots of situations where the House of Commons decides on things on the basis of moral principle and, I guess, public interest, and then we ask the public sector to absorb it. And if that causes operational problems, well, we solve those problems separately. In 10 years in this House, I cannot remember anybody ever standing up and saying we shouldn't do this because the public sector can't cope.
Just recalling being on the domestic abuse bill committee, and we heard time and again from public sector representatives that bringing in changes such as a domestic abuse register would bring extra work and it would be difficult. It is their job to flag up those points, but it is our job to assess what is the right thing to do in legislation.
Yeah, I think the Honourable Lady puts it exactly right. These are two separate questions, and we should not conflate the two. And certainly, we should not allow the House of Commons to be constrained to do what it thinks is the right thing by those capacity constraints. What we should do is do the right thing and then put pressure on the government to provide the facilities that we think are required. Yes.
Daniel Francis.
Thank you, Chair. But on that very point, of course, in our oral evidence, we weren't able to take witness evidence on these changes to these clauses because we didn't understand the repercussions of these clauses at this stage. I don't know if the honourable member's got...
Well, there were a number of questions, as I recall, at the oral evidence stage about the notion of there being a panel. That were put specifically, I think, when we had the panel of lawyers in front of us. We did ask about that, but the Honourable Gentleman is right. The issue was an emerging one at the time, and that is the nature of this kind of iterative policy making or legislative process that we're going through at the moment. As the government has said, it's going to produce an impact assessment, so we can all have a look. It won't be long, 3 or 4 weeks, and then we'll all be able to make a judgment. So first of all, I wanted to separate those two issues and point out that, as I read it, the opinion of the judiciary was that we didn't need a third layer. And actually, it should stop at 2 doctors. The House of Commons did not agree with that we should have this scrutiny and authorisation level. Now, if we're having a scrutiny and authorisation level, I became convinced by the evidence that we did hear about, and actually some of the opinions of people who opposed the bill, about the insertion of greater expertise at that level. And so I was willing then to say, well, if we're going to have scrutiny, let's have expert scrutiny, rather than a High Court judge who is by nature highly skilled, but nevertheless a generalist. Right? So that was the point at which I moved my position to support the amendments that the Honourable Lady has put through. And then the final thing I just want to say briefly is we've talked an awful lot about the structure. I would just say to those members who are proposing amendments to the structure that's proposed and trying to introduce either a notion of an adversarial hearing or policing the discussion that needs to be or increasing the bureaucracy, as the Honourable Member from Ipswich said, we need to take care to tread lightly on people's final moments. Right? We have to have at the heart of our thinking the notion that we are filling these people's final days and hours with possibly stress, with bureaucracy, with a sense of jeopardy about whether they're going to get permission for what they want, right, for what they've declared to 2 doctors, for the forms that they've filled in, and at the back of their mind that they don't have long left. And so while I understand the motivation of those who are trying to amend and restrict this ability and elongate the time, I do ask them to bear that in mind and help us to strike a balance between, yes, having a system that gets to a robust answer, but, as I say, treads as lightly as possible on the remaining lives of these people who are facing their end. It's impossible, perhaps, for all of us to realise what it is like to be in those final 6 months. I hope none of us ever do get that call. We never get that envelope. We never have to go and sit in front of a doctor and be told that. But it must be completely devastating. And we must not allow this to become the primary purpose for people's final 6 months of existence. As a number of members have said, this is something that people want as a card in their back pocket. They want to have it as a sense of insurance and security against pain and agony at the end. A large proportion of them won't use it. And so just striking that balance, I think, is critical. And after much discussion and work, I think the Honourable Lady has done just that, so I'll be supporting her.
Thank you, Madam Chair. I want to speak in response to some of the points that the member for East Wiltshire made. And in doing so, I did look back on the Hansard debate on second reading and his position there, and I'm somewhat confused because in his speech there, he was entirely dismissive of the judge as a safeguard, and now suddenly we've got in committee, he seems to have had a Damascene conversion in favour of it. And I think this gets to the question of, as others have asked, are there indeed any safeguards that would satisfy in principal opponents of the bill? And I entirely respect the position of principal opponents of the bill, but to come on to these amendments in particular, the point...
I'm grateful to him and I look forward to hear his substantive remarks. But to explain to the honourable member, there are no safeguards that I think will make an assisted dying bill adequate. So, no, I'm going to oppose the bill whatever happens, because I recognise that I just think it would be dangerous for people however we do it. But if we're going to do it, let's do it as safely as we can. And there are definitely ways in which we could improve the safety of this bill. as have been suggested in the many amendments that I've supported. To the point about the judicial stage, I am very critical of Clause 12 as it stands, because I don't think that it provides the sufficient rigour, and there are major questions around the capacity of the judiciary, as has been discussed. But the principle is absolutely right. It is important that if we're going to do this, we have a judge to make the final decision. So I wasn't satisfied with the bill as presented. I think we should be building on it rather than reducing that judicial safeguard.
I thank him for the point, but in a world in which one cannot describe any version of safeguards that would be possible, and in light of some of the other conversations we've had, one is led to believe, entirely respectfully, that some people are in principle opposed to the bill in any instance. And the point around that the honourable lady, the sponsoring member, made at second reading, that this was the safest in the world around the judge, it wasn't just the fact that there was a judge, it was the fact that there was a third tier. And that is not something that is in place in Oregon, in Australia even, as we've heard in evidence. So now we are not only going to have a third tier of scrutiny, but we're going to have 3 professionals who must unanimously accept that the strict conditions for eligibility have been reached. So the suggestion that by amending out away from a High Court model to a panel model means that we have to recant any suggestion that this is the strongest in the world, I absolutely refute. The honourable gentleman, I'm going to just continue this point if I may. The honourable gentleman asked, what is the purpose of this panel? It's very, very clear, I believe, as set out in New Schedule 21. It is on determining eligibility for assistance, as set out in the stringent rules and conditions that we will set out in the bill. And he goes on to ask, what was the purpose of the judge? Well, the judge, suggesting that it's a bureaucratic role, as New Clause 14, 4C, I believe it is, makes clear, the Commissioner's role is for making arrangements for panels. And New Schedule 2 is clear that the Commissioner has powers to give guidance around the procedure and practice of those panels. So clearly, a judicial figure with experience of proper process and procedure it's absolutely right that that person is a judge who's the Commissioner, setting out the procedure for each of the panels. Furthermore, he made a point around MDTs, and again, I would gently say, I'm not sure that the honourable gentleman has worked in or around healthcare as I and other members have. The suggestion that individuals at the end of their lives are not in contact with multiple professionals is highly implausible. We are blessed in this country that we have people with cancer, we have some of the best cancer nursing in the world, that we have palliative care social work. And, he asked before which evidence bodies had come out in support of this change. Well, the Association of Palliative Care Social Workers say, and I quote, "The inclusion of social workers as core members of these panels shows that Kim Leadbeater and her colleagues have taken on board our arguments that social workers are uniquely qualified and equipped to undertake the complex and sensitive tasks of assessing mental capacity and safeguarding individuals who may be subject to any form of undue influence or coercion." So, I know I'm in the flow, so I'm just going to keep going because I'm mainly rebutting at this point, and I don't want to open the debate that much wider. So we already have, invariably, individuals at the end of their life with multidisciplinary input. That is appropriate to them. And we've heard already how the independent doctors and the panels will rightly seek input from all those involved in care. And I know it has been some time since the Honourable Member and I had an exchange around the difference of the ventilator test. And I know that we have a fundamental, again, philosophical difference. That I believe that a dying person who says, "Please, doctor, please turn off my ventilator, I want to die," it is fundamentally not particularly not different to that person saying, please, doctor, let me take that medicine, I want to die. Now, and I would assert that the person in the street is closer to my view of the situation than it is to his. Though I totally respect that there are philosophical people with belief have different philosophical opinions about that. But let's not forget, we are having this debate sometimes around the correct oversight of this third tier, as if, in a theoretical manner, as if these people are not dying anyway, and as if deaths around refusal of treatment and suicide is not happening anyway. I'm happy to give way.
I'm grateful to him. Just on that point, and let's not rehash the argument about whether there's a difference between withdrawing treatment and actively killing somebody or giving them the opportunity to kill themselves. But on the point about withdrawal of treatment, does he acknowledge that where there is dispute over whether somebody should have their treatment withdrawn, it goes to a court, and that there is representation from both sides of that argument about whether the treatment should be withdrawn? So if he's saying that these measures are essentially identical in principle, then surely we should have the same mechanism to resolve disputes.
I thank the honourable member for his intervention, but I'm afraid he's confused. It goes to the Court of Protection, where the individual themselves is not capable of making that decision, and there is a dispute about what the best interests decision may be on that individual. That's entirely different to the dying person themselves saying, please turn off my ventilator. In that case, the Mental Capacity Act applies, as we have discussed at length in this committee, but there is no checks further for coercion, for capacity, for motivation in the way that has been described. So the suggestion that here, when we now have, with the 3 panel members, at least 5 professionals who must all be satisfied that there is no coercion. How many individuals, I see a sort of speculation, including in social media, around the amount of people that might seek an assisted death that may be subject to coercion. I would invite individuals to consider how many people who refuse treatment at the moment without any of those checks are subject to coercion. How many people that go to Switzerland or commit or end their own lives are subject to those checks? We don't know, because we have no robust oversight of those instances. And so while I have absolute sympathy, and I think my honourable friend from Bexleyheath and Crayford made a really thoughtful and personal speech, as he always does, the exact same instances that he describes would be permissible in right here and now. So, and in response to the honourable member, the lady from Reigate, moving the amendments around family, and she shared some upsetting stories, I think it was from Canada, around the impact of family on that. First of all, of course, would point out that Canada's system is nothing akin to the one that we're proposing here, because it doesn't have the third tier protections that the honourable lady in this bill proposes. But I think it's also important that we centre this back talking about dying people here in the UK, and that we have some of their voices and experiences and their families in the room. We know that 650 terminally ill people end their own lives already at the moment in the UK. Arnold Douglas's dad, Ian, took his life the day before his 60th birthday. He was at the terminal stages of MS and had ended his own life without notifying his family because he felt he had to protect them because of the state of the current law. He managed to obtain opioids from the dark web and subsequently overdosed. In his final note, he said, "I would like to put on record that had we had more sympathetic assisted dying laws in this country, in all probability, I would still be here today." I'll use one more example. Peter Wilson discovered his wife Beverly dead in their home on the return trip from London. She had terminal esophageal cancer and had taken her own life alone at their home in Nottinghamshire when she knew Peter would be 120 miles away. Even though Peter could prove he wasn't present at the time of death, he was questioned by police for 7 hours, fingerprinted, photographed, within hours of her death. This is the current situation that families that we've discussed about maximising their care are facing in the UK. And that is why we need a change in the law. That is why we need a change in the law that includes a robust third-tier oversight. Now, I'll just conclude. This whole process, and I'm really pleased as a committee we have made, I think, significant strides in understanding of each other, but also in passing some more important amendments. But the honourable member, again from East Wiltshire, made a point in his speech around voting against Clause 12 on procedure, as if it was outrageous that we would be doing this sort of procedure and that such amendments were not acceptable. In his second reading speech, again, he said, and I quote from Hansard, "Members should not hide behind the fiction that it can be amended substantially in committee and its later stages. The remaining stages of the private members' bill are for minor tweaks, not the kind of wholesale restructure that we would need." So, I again gently say, I understand there are in principle opponents of this bill, but we are working in good faith through these amendments to respond to the evidence that we've heard, to improve lives for families and dying people in this country. And that's why I'm proud to be supporting these amendments in the sponsor's name. Thank you.
Nisha.
Thank you, Chair. I am going to be moving and speaking to Schedule 2B, but before I do that, if I may address some of the points in terms of what the Honourable Member has just from Sunderland Central has been talking about. Just to clarify for the record, Chair, the co-chair of the social workers, the palliative social workers, the Association of Palliative Social Workers, Glyn Berry, has not endorsed, of which there are 200 members, there are 200 social workers for palliative care in the country as it stands, and has categorically said that these panels woefully are not they are not supporting the panel structure as it is, as they fail to support the assisted dying, the requirements, what this bill is intending to do. That's the first point I wanted to make, and I'm happy to send him the reference for that. Furthermore, the member for West Hampshire earlier referred to panels in particular, and that these panels, and again I try to intervene and ask directly, but I will mention something I wanted to ask the member, and I'm happy to give way should he wish me to. He told Hansard Society that the honourable member said he was not supporting palliative care specialists at an earlier during the bill, simply because this issue of palliative care would be addressed in the panels and the panel structures, and actually that hasn't happened either. So there are some concerns that I just wanted to put on the record from my perspective, Chair, before I move on to my substantive speech. Going back to the amendment new schedule 2B tabled by the Honourable Member for Derby North, Catherine Elser. This amends the proposed new Schedule 2 from the bill sponsor to ensure that the official solicitor will nominate a person to represent the applicant before the panel. As it stands, Chair, NS2 does not require the Commissioner to give guidance about the practice and procedure of panels. If guidance is passed, then Section 8, subparagraph 2, states that the panels must have regard to any such guidance in the exercise of their functions. The member for Derby North's amendment removes these two subparagraphs and replaces them with the following. 1. The Commissioner must give guidance about the practice and procedure of panels. 2. Such guidance must prescribe a procedure which, in relation to each application, appoints the person nominated by the official solicitor to act as an advocate to the panel. 3. Panels must have regard to such guidance in the exercise of their functions. What effect would this have? I would refer honourable members to the written evidence submitted by Ruth Hughes, a senior barrister due to be appointed King's Counsel on March the 24th. The written evidence number is 161. Miss Hughes notes that she has 17 years' experience of specialising in mental incapacity and the law in relation to vulnerable adults. She has advised the Ministry of Justice on capacity-related issues. She describes herself as one of the most experienced barristers specialising in the property and affair of persons who lack mental capacity in the country. In this context, I think it is particularly noteworthy that Ms Hughes has frequently appeared in court instructed by the Official Solicitor's Office and the Office of the Public Guardian. She says that in my professional experience, financial abuse of a vulnerable and those who lack mental capacity or are approaching the borderline is depressingly common. Ms Hughes is not someone who opposes this bill at all costs, but someone who seeks to strengthen its safeguards for those at risk of coercion. She states in her evidence that whilst I do not oppose the bill, I am highly concerned that the safeguards proposed are insufficient to protect vulnerable people from exploitation for financial gain. Ms Hughes goes on to say, I suggest it would be profoundly disturbing and wrong for Parliament to enact legislation which put vulnerable people at risk of being killed for financial gain without creating adequate safeguards to protect them. Those are very strong words from someone who I suspect is not in the habit of crying wolf. If we hear that kind of warning from a senior lawyer with Ms Hughes' specialised knowledge of protecting at-risk adults, we should certainly listen. Ms Hughes was a strong supporter of the original bill's use of a High Court judge as the authority who would decide on assisted dying applications. She wrote, I suggest that the judicial safeguard is fundamentally important. She recommended, however, that the bill should be amended to include 5 additional safeguards. I'm pleased to say that my honourable friend, the bill's sponsor, has accepted one of these 5 proposed protections, the requirement to hear from the person who wishes to die, as Ms Hughes has advocated. Her 5th recommendation bears directly on this amendment, Chair. She says that the bill should be amended to include an advocate who would, to quote Ms Hughes' words, ensure that the evidence in support of a claim is appropriately tested. Ms Hughes made that recommendation for an advocate when my honourable friend was still advocating the High Court judge as the arbiter, rather than the panel. But I do not see that the change from court to panel has in any way weakened the argument she made for an independent advocate. Explaining why she wants to increase safeguards, she says that the bill is as written, there was likely to be significantly less scrutiny of a decision by the court in relation to assisted dying than there is, for example, currently in relation to a decision of the Court of Protection to withdraw life-sustaining treatment from a person, or even a decision as to where a person lacking capacity should live or with whom they should have contact. Ms Hughes said that one problem was that, and I quote her words, importantly, there is no person appointed to assist the court to consider and test the evidence before it. She went on to say, our court system is inherently adversarial. Generally, 2 or more parties to a dispute will present evidence and argument to the court, and the court will make findings of fact on the evidence and come to decisions on the law in accordance with those arguments. The court is not hidebound, but equally it is not set up to obtain evidence itself. Ms Hughes argued, a scheme which does not provide for an independent party to consider the evidence and present arguments against an application will unlikely be robust and will not be well designed to identify, for example, a lack of capacity or the existence of coercion or pressure. This part of her evidence seems to me to be particularly important. Doctors, for example, may not be well placed to identify coercion, pressure or control. She goes on, in my experience, they, by which she refers to coercion, pressure or control, are often missed by solicitors taking instructions for the making of gifts or wills. Ms Hughes carries on and argues that the best solution, perhaps, the only good solution to this problem would be to require the official solicitor to act as an advocate to the court in cases brought under the proposed legislation. Here, it will be helpful if we explain the term advocate to the court. The Ministry of Justice publishes the following explanation on what an advocate to the court is and what they do based upon a 2001 memorandum agreement between the Attorney-General and the Lord Chief Justice. The Ministry says, a court may properly seek the assistance of an advocate to the court when there is a danger of an important and difficult point of law being decided without the court hearing relevant argument. In those circumstances, the Attorney-General may decide to appoint an advocate to the court. The Ministry of Justice explanation continues. It is important to bear in mind that an advocate to the court represents no one. Their function is to give the court such assistance as they are able on the relevant law and its application to the facts of the case. I would suggest that we should all see the advantage of being able, through the official solicitor, to give the panel the assistance of specialist lawyers. We should particularly see the advantage of the official solicitor being able to appoint barristers experienced in cases where capacity was in doubt or where people were possibly being coerced. It is worth mentioning that the Ministry of Justice explanation goes on to say that an advocate to the court will not normally be instructed to lead evidence, cross-examine witnesses or investigate for the facts. I think the word normally is one that may be important in this context. Perhaps the advocate will not carry out these functions when acting to advise assisted dying panels. But we should note that the Ministry's guidance does not state that they will never carry out such functions. As we have remarked more than once, we are in unmarked territory here. I will end by quoting some more of Ms Hughes' evidence because it is very clearly written by a person who is an obvious expert in her field. She says, "In my experience, it is not uncommon where a vulnerable person is controlled or lacking capacity for the person to be apparently expressing wishes in a clear and forceful manner. This can easily be mistaken for a person acting freely with capacity." To be honest, honourable members, I think that statement is a powerful counterpoint to some of the confident claims we heard from other witnesses that it was relatively easy for doctors to detect coercion. I think some of the Australian and California witnesses were particularly noteworthy in that regard. Ms Hughes goes on, "In short, the risks of the bill are real and substantial. The challenge for Parliament is how to mitigate them, and the current drafting is inadequate. I strongly suggest, honourable members, that this is evidence that we should not ignore. It comes from a distinguished lawyer who is not an opponent of this bill, but fears that as drafted it will not protect the vulnerable. She has offered us what seems to be a very workable solution to the problem that concerns her: create a mechanism to involve the official solicitor. The amendment to new Schedule 2 tabled by my honourable friend for Derby North would allow us to put that into practice. I would hope that all members of the committee can support this measure and increase the protection this bill offers to vulnerable people at risk of coercion. Thank you, Chair.
Sean Wood. Thank you very much, Chair. Pleasure to have you here for this afternoon. I wasn't intending on actually making a contribution, but the number that have been made, and I wanted to respond to them because it's been a really interesting and important session of the committee. Just in response to my honourable friend, Member Ipswich, I think he's right in the sense that the panel, I see it as a genuine attempt to respond to the evidence that we heard during the witness sessions to improve this process. I see that as, I take that absolutely as read, and particularly the evidence of people like Rachel Clark, looking at the fact that her view is that coercion is happening and we should take the NHS as it is, not as we would like it to be. And I see that this attempt at putting a panel in there as a response to that. In response to the member for North West Hampshire, and he is absolutely right to state that if there's a moral imperative to do something, the Parliament should look at passing it and then figure out how the public services should figure out how they implement it afterwards. He's right in that. There is obviously a question in here about whether there is that moral imperative, but he's right to point that out. on the panel, my view is that while I take it as a very sincere attempt to strengthen in this bill, I feel that the panel put before us isn't strong enough. Hence the amendments that I proposed yesterday from my honourable friend, Member for Derby North, in that I think it would ensure that it was done properly and robustly. Nobody wants to see people dragged in front of a court when they're unwell, but there is the matter of making sure that people are safeguarding, and we do have this concern about coercion that is integral to ensuring that we have public trust on this. And so I think I would once again urge that those are considered by the proponents of this bill as we go forward. More than happy to give way to that.
I think it makes a really good point, especially on the issue of coercion. I guess my question is, I mean, we've obviously had amendments that have been passed in terms of coercion training, but in my honourable friend's opinion, would the court system as it stood actually deal with that concern you have around coercion, or is the panel more able to deal with that kind of concern?
Thank you very much, Chair. I was actually going to come to that as my next point, in the sense
Sorry
that...
for preempting.
No, absolutely. I absolutely understand. It's a very, very good question. As I said, I think the panel is actually done with the right intention. I think it would improve the process in many ways. My view is very similar actually to Member for East Wiltshire. It's possibly in one aspect where we're in agreement. And I think it's just at the wrong part of the process. I think if it was earlier in the process, I think it would improve things. The capacity in the courts, I think, is an issue, but I take the point made by the member for North West Hampshire that it's a bit, if we want the courts to do it, they need to get on and do it. But I do think it's a really important process. I again look though at the, and I keep coming back to the issue of one, what we are asking the state to do. There is the role of the patient, the importance of implementing the wishes and the autonomy of the patient, but there's also what we are asking the state to allow to be done in its name, and that's something that I think we have to take very, very seriously as well. What is it that we are saying the state should be doing? But there's also the matter, there is the severe matter of public trust, and the condition of the National Health Service, the issues of capacity in the courts that my honourable friend himself touched upon in his comment, are things that mean that there is a considerable disquiet about this and a concern about how robust this process is going to be, which is why I feel that even though I think that the panel process at the start of this is in many ways would improve what was put to the House at the second reading, I think that judicial oversight at the very end would provide the reassurance to vast swathes of the public who are concerned about this, as well as to members of the House who absolutely...
I'm very grateful. He's making a very, very important point there, and I completely agree with him. Does he agree with me that, as he says, the sponsor recognised the problems with the lack of a multidisciplinary team in the process and the problems of the court capacity, and in an attempt to address both of those problems, what we've now got is a multidisciplinary team acting instead of the judicial point, and what we really need is both. We need a multidisciplinary assessment at the beginning, properly constituted, and then we need the final process being an approval by a judge. Does he agree with me that would be a better process?
Having thought on it, that would be my preference. And so it does leave me in a difficult position, in that I very much do think that the panel has a lot to be said for it, and I think it would improve this process in many, many ways. But I cannot get around the fact that the judicial aspect of it was put very strongly before Parliament in terms of making sure that we had those safeguards. It did provide reassurance to members of the House and has provided reassurance when I've been out on the doorstep talking to people who are in favour of this bill, people who are saying, wanting me to vote in favour of this bill. One of the things that they have said to me is, well, I believe that this proposal is safe because it's got two dots and because it's got judicial oversight, and that does come up, and that's why I am in the position of thinking that we need to keep that judicial oversight in, even though I recognise the very genuine attempt by my honourable friend, Member for Spen Valley, by putting this panel in there to improve on some of the aspects and the concerns that were raised during the witness assessment. I've just said that, sorry.
Minister. Nashan?
Sorry, I'm just going to, if I may, Chair, just speak to the issue of judicial oversight of the panel. and the whole NC21 in total. One of the things that concerns me is I'd like to understand, and perhaps the Minister or the sponsor of the bill could help me. We've been talking a lot about judicial oversight, Chair, and my concern is we have got, even if we had the judicial oversight, the fact that there's no liability for if something goes wrong, where does that sit with the judicial? So we have judicial oversight or we would have had judicial oversight. Now we have panel oversight, non-judicial oversight over the decision. But what if somebody, even then, did go down the assisted dying route, and at that point, after that, there was an issue raised with that? What recourse would anybody have, family members, etc., to hold anybody liable if they did something wrong, including the Commissioner potentially?
Minister.
Thank you. Thank you, and let me say that again, that it's a pleasure to serve under your chairship. As my colleague and I, the member for Aberfan and Masteg, have made clear throughout this debate, the government continues to remain neutral on this bill and does not have a position on assisted dying. So once again, my remarks will focus on the legal and practical impacts of the amendments with a view to assisting the members of this committee. I will first speak to the amendments 371, 372, 373, 377, 378, 381, 388, 390, 391, New Clause 14, New Clause 15, New Clause 17, New Clause 21, New Schedule 1 and New Schedule 2, all proposed by the member for Spen Valley. In executing our duties to ensure the legislation, if passed, is legally robust and workable, the government has worked with the member for Spen Valley in relation to these amendments, which propose the Voluntary Assisted Dying Commission and panels. They reflect the member's intent to replace the court approval process currently set out in the bill. And to confirm, this change was driven not by capacity concerns from within government, but by the sponsor's policy intent. Let me be clear. The High Court stage could be made to work, but if this committee and if Parliament elect for the Commissioner and panel model, then the state will work to deliver that. Amendments New Clause 14 and 391, the establishment of the Commissioner. New Clause 14 and consequential Amendment 391 would provide for the establishment of a voluntary assisted dying Commissioner. In keeping with other appointments of this significance, the Commissioner would be appointed by the Prime Minister, and the individual in post must hold or have held, so it's not just sitting judges, but could be a retired judge, as a judge of the Supreme Court, the Court of Appeal, and the High Court. The clause sets out the central functions of the Commissioner, which will be detailed further in New Clauses 15 and 17 and New Schedule 1. The Commissioner, as we've heard, would receive documents, including the reports from the coordinating doctor and declarations under the legislation, make appointments to the list of persons eligible to sit on assisted dying review panels, and refer cases to these panels, which would replace the role of the High Court in the original draft of the bill. In addition, the Commissioner would also have the responsibility for monitoring the operation of the Act and reporting annually to Parliament, something which we will come to, no doubt, in Clause 34. But I think it's important to pause there because that is one aspect in which the Commissioner model is distinct from a court or a tribunal. It is serving multiple functions, not least the monitoring of the operation of the Act and reporting on that annually to Parliament. Amendment New Schedule 1, which is the schedule which deals with the Commissioner. New Schedule 1 introduces a schedule which contains practical arrangements for the office of the Voluntary Assisted Dying Commissioner as established in New Clause 14. In practice, we anticipate that the Commissioner's office would be a non-departmental public body. The establishment of such an office to support the government-appointed chair or commissioner is common practice for roles of this nature. For example, the Investigatory Powers Commissioner is one such model, which is chaired by a person who is holding or who has held high judicial office. The schedule also introduces the role of a Deputy Commissioner who, like the Commissioner, must have been appointed by the Prime Minister and hold or have held office as a judge of the Supreme Court, the Court of Appeal or the High Court. Both the Commissioner and Deputy Commissioner would be appointed for terms of 5 years with their remuneration set by the Secretary of State. The Commissioner would have the ability to appoint their own staff, have obtained approval from the Secretary of State in regard to the number of staff, remuneration and terms, as well as providing an annual statement of accounts. In the ordinary way, such a public body would be subject to other statutory provisions, not least the Equality Act 2010. Referral to the panel. Amendment New Clause 15. New Clause 15 would establish the mechanism for the referral by the Voluntary Assisted Dying Commissioner to a Assisted Dying Review panel. Where the Commissioner receives a first declaration from the person seeking assistance and reports from the coordinating and independent doctors as to their assessments of the person, including a statement by those doctors as to the person's eligibility for assistance, they would be required to refer the case to a panel as soon as reasonably practical. In practice, the task of organising the work of each panel would fall to the Commissioner's office. The coordinating doctor would be required to inform the Commissioner where a first or second declaration is cancelled. Where the Commissioner is informed of the cancellation of the first declaration, the Commissioner must not refer the case to a panel or inform the panel to disregard the application if already referred. Chair, Amendments 371, 372, 373, 377, 78, 378, 381, 388 and 390 are what I come to next, and these are all consequential amendments to New Clause 21. Together, they establish the mechanism for consideration of cases by the assisted dying review panels in place of the High Court. Panels would be required to review each case and issue a certificate of eligibility where they are satisfied that all the requirements set out in the bill have been met. Yes, I will.
I'm grateful to the Minister for giving way. I'm just seeking clarification. In the original draft of Clause 12, at 1C, the High Court will give a declaration that the requirements of the Act have been met, but in New Clause 21, which I had marked and now I won't be able to find, at 6A, the panel is required to issue a certificate of eligibility, which the Minister just referred to. Can I seek the Minister's guidance? Is it the view of the Government that a High Court declaration has equal weight in law to the certificate of eligibility that's set out in New Clause 21? And I'm asking particularly because this will be relied upon if, for the purposes of suspending the Suicide Act 1961, under which that would otherwise be a criminal offence has been committed. And this certificate of eligibility will need to be relied upon to demonstrate that no criminal offence has been committed under that law. So that is why I'm seeking the Minister's guidance. Is it her view, is it the view of the Government that a High Court direction as originally required can now be fully replaced and have equal weight this certificate of eligibility? Thank you, Chair.
Minister.
I'm grateful for her intervention. As I understand it, everything has to be internally coherent in whatever the final version of the draft bill. And within this structure, because it is a panel that in this case that is issuing the certificate, its own sui generis certificate appropriate to this process. The declaration that was referred to in the earlier draft, in the normal way, is a declaration that the High Court would normally do. But given that this is on the face of the bill, given that it is in primary legislation, it would have legal force and would, if it were internally coherent with the rest of the legislation, have the legal effect of operating coherently with the criminal offences and indeed with the suspension of the Suicide Act, as she's just asked me. That's my understanding.
I'm grateful to the Minister for giving away. So can she just... I think my original question was more, does it have the same legal force as a High Court direction?
Minister?
My understanding is it would, yes. And if I'm wrong about that, then I will obviously come back and correct the committee, but my understanding is it would. I mean, they're two different things. One is called a certificate of eligibility, one is a High Court declaration. But in terms of how they operate within this legal scheme, my understanding is they would have the same legal effect, and they're intended to have that. Right, I was on to the consequential amendments, which I was giving a long list to New Clause 21. So under New Clause 21, the panel must hear from and may question the person seeking assistance and the coordinating doctor or the independent doctor or both. The panel may also hear and may question the person's proxy, if that's relevant, and any other person, including those appearing to it to have relevant knowledge or experience. This could include family members or other individuals interested or with an interest in the welfare of the person, as well as other experts. The new clause is explicit that the panel must not grant the certificate of eligibility if they are not satisfied all the requirements have been met. Further consequential amendments introduce references to the certificate of eligibility throughout the bill. Once the panel has made a decision, they would be required to notify the person seeking assistance, the coordinating doctor, the commissioner, and any other person specified in the regulations. The amendments from the member for Spen Valley do not, as others have pointed out, do not spell out or set out every step in the process or the procedure that the panels would be expected to follow. That is left down the line to secondary legislation and indeed to the Commission itself and the Commissioner to produce its own guidance for how the panels and the panel procedure is intended to be governed and regulated. And this is in line with the approach to legislation more broadly, where the main objectives are set out typically in primary legislation, with secondary policy issues, technical and administrative matters dealt with by secondary legislation, regulations and guidance. And if you want to see a comparable model, the parole board, its functions and its constitution are set out in primary legislation. The rules governing it are set out in secondary legislation in the parole board rules, but then there is extensive guidance produced by the parole board itself. And indeed, there might be some analogy that one could draw between that example and the sort of model that the sponsor amendments speak to. New clause 21A, B, C and D. These amendments seek to change the criteria used by the panel when considering whether to grant a certificate of eligibility as set out in the sponsor's new clause 21. I believe these are the amendments, or at least some of them, that the Honourable Member for Reigate in relation to the appropriate standard of proof. Amendment new clause 21A would require the panel to be satisfied beyond reasonable doubt, i.e. the criminal standard of proof that the criteria of the bill have been met. In law, the balance of probability standard means that a court is satisfied an event occurred if the court considers that in the evidence the occurrence of the event was more likely than not. The civil standard is currently used in end-of-life decisions and in other similar contexts. In addition to being the relevant standard of proof in deciding whether a person has capacity under the Mental Capacity Act, including for serious medical treatment, the civil standard, the one that would be applied here under new clause 21, is also applied in serious cases such as suicide inquest cases, withdrawal of life support, and in childcare proceedings. In practice, the panel would only establish a case on the balance of probabilities on the basis of strong evidence, including contemporaneous documentation, records, or on hearing from the relevant persons whom they're required to hear from. And the panel's decision must be unanimous. So you've got...
On that point,
yes, of course.
No, sure.
I'm grateful for the Minister to give way. She says that we've heard this before, that the panel's decision must be unanimous. Yet I can't see, and I've tried to look for it in the bill, where it says it has to be unanimous. It does not state that specifically. My understanding is that two people could nod their head, the other one wouldn't have to, and it would still pass.
It is
Minister.
I believe it's in there. Let me just find the relevant provision so I can refer you to it.
I'll find it if you want to cook it. I can't find it. It's a majority vote, not unanimous.
It's majority in respect of other decisions that the panel may make, but in respect of the certification, it is unanimous. I just need to find the right provision. he bears with me for 1 second. It's because it's in the schedule, not the schedule.
It's in the schedule.
Let's get there.
It's on page 74.
Oh, here we go. The decisions of the panel. So this is a new schedule to...
Page what? 74.
Yes, and this is part 5, and I think subsection 2, the Honourable Lady, if she refers to subsection 2 of part 5 of that schedule, decisions of the panel may be taken by majority vote. So that's decisions whether to hear, for example, from an additional expert, whether further investigation is required in respect of some aspect which the panel may be concerned about, coercion or capacity. So those decisions can be taken by majority vote. But in respect of the certification and the granting of certificate of eligibility, if she refers to 5 subsection 3, the panel is to be treated as having decided to refuse to grant a certificate of eligibility if any member votes against the decision to grant such a certificate, which is slightly, let me just finish my sentence, which is a slightly mealy-mouthed way of saying, if any member of the panel resists the grant of the certificate, then no certificate can be issued. I'm happy to give...
I just wanted to support the Honourable Lady. She's absolutely right. And it's clearly intended that there should be a unanimous decision, but in fact, as the Honourable Lady pointed out, if one of the members decides to effectively abstain, then the procedure does go ahead. So it's not that they all have to actively support the decision. Only 2 of them have to actively support the decision. One of them could have their doubts, sit on their hands, and it would still go ahead.
Minister?
Well, I thank him for that intervention, and that may be something that others wish to take away, whatever the policy intent may have been. But it may also be that in order to give that there's I don't think it's on the face of the bill, in fairness, where there's a requirement to give a positive indication of a decision either way. But I think clearly the intention behind 5.3 is that there's unanimity in relation to the grant of an eligibility certificate.
Sorry.
Daniel Francis.
Thank you, Minister. Thank you, Chair. You know, I was once at a planning committee where one member of the committee voted in favour and all the other members abstained. And the recommendation went through 1-0. And technically the way that reads currently to me is that could happen. One member could vote in favour and 2 could abstain, and that would therefore not be unanimous. So I'd like the Minister's comments on that.
Minister?
Well,
Minister?
I think we're discussing here how you construe that provision in part 5 of the new schedule. Obviously, and I should reiterate this, the election for, or the apparent intent to have the, call it what you will, safeguard of unanimity here, behind that provision is the sponsor's intent. If there's any feeling or suggestion that the drafting doesn't fully reflect that intent, that can obviously be tightened up. But I think clearly on the face of the bill, there's an intent to have unanimity in respect of the final decision in terms of certification.
Will the Minister give way?
Kim Ledbetter.
I thank you for giving way. It absolutely is the policy intent that there should be a unanimous decision of the panel. If there is any lack of clarity, I'm very happy to look at working with official drafts people to tighten that.
Minister?
Thank you. I thank the various members for those interventions. So, in respect of the standard that would be applied in order for the panel to be satisfied, in practice, as I was saying, the panel would only establish a case on balance of probability in these circumstances on the basis of strong evidence. In other words, the more serious the issue to be determined, the closer the scrutiny and the stronger the evidence required. Introducing a requirement for the panel to be satisfied beyond all reasonable doubt at this stage would be different and would create a difference or a divergence to the standard applied by professionals earlier in the process. So, for example, to the standard applied by the doctors in the first and second assessment, as I think the Honourable Lady acknowledged in her speech earlier, to ascertain whether, amongst other things, the person has capacity to make the decision to end their own life or whether they have a clear, settled an informed wish to do so, and that they have not been pressured or coerced. And that creates the problem, potentially the problem, of making the application of the bill incoherent, because of course if a civil standard has been applied earlier in the process, then the higher criminal bar could never be satisfied at the panel stage. So there's the principal decision for what standard should be applied here, and as I've said, the civil standard is used in other end-of-life decisions, but then there's also the question of the internal coherence of the bill. Amendment New Clause 21B. I will give Rebecca.
I thank the Minister, and I really appreciate the very clear way you are laying all of this out, so thank you for that, and I completely acknowledge what you've just said, and as you rightly said, I alluded to that in my speech, that I'd tried to put that change through earlier on, was unsuccessful, and now trying to put it through here. But could the Minister comment on the meaning of satisfied? So if we're not going to have beyond reasonable doubt, can you just expand a little bit about the meaning of satisfied and whether you are comfortable that that is clear enough for these purposes?
Minister.
I thank you for that intervention, and the answer is yes. I, on behalf of the government, am satisfied that that would be commonly and well understood by those both applying it and any court construing it, that what the standard to be applied is the civil standard, and that would be understood by not just the Commissioner in terms of laying down the rules for the panels, but the panels themselves. And as Lord Bingham, as he then was, one of the most distinguished judges that this country has ever produced, the civil standard, I think it's important to recall, is a flexible standard to be applied with a greater or lesser degree of strictness according to the seriousness of what has to be proved. And I think there is no doubt, based on what we've debated and what Parliament's debated, of the utmost seriousness of the issues here. But to answer her question, the answer is yes, I think it is clear, and that is the government's position. Amendment New Clause 21B would enable the panel discretion to refuse to grant a certificate of eligibility where the requirements stated in the bill are met if they believe there are, and I quote, particular circumstances which make it inappropriate for the person to be provided with assistance. The government's view is that this could risk unpredictability and inconsistency in the panel's decision-making and reduce legal certainty for the person seeking assistance, as well as for the panel. Amendment New Clause 21C concerns the three specific requirements under subsection 2C, that the person has capacity, H, that the person has a clear, settled and informed wish to end their own life, and I, that the person made the first declaration voluntarily and was not coerced or pressured by any other person. The amendment would mean that despite finding that these criteria have been met on the balance of probabilities, the panel could stay proceedings where it believes that there is a real risk that they have not been satisfied. As with Amendment New Clause 21B, this could result in uncertainty for the applicant and in terms of what is required of the panel in their decision-making. As I referred to earlier, in a lot of these decisions, the question of whether somebody has capacity or not, the question of whether one is that person is being coerced or not, ultimately, for each panel member, it's a binary decision. The person either has capacity or they don't. And I think that in practice, applying the civil standard with the rigour that Lord Bingham spoke about in the most serious cases, that in circumstances where the panel or its members identify that there is a real risk, either one would expect them to exercise their discretionary powers to seek more evidence, to remove that risk and that doubt, and if that persists, then to refuse and to make the binary choice that that person doesn't have capacity or is in fact being coerced, or vice versa. Amendment New Clause 21D would require the panel to hear from and question both assessing doctors, as opposed to the requirement that the person must hear from and may question one of the doctors and may hear from and question both. The amendment would also require the panel to hear from and question the person seeking assistance and the person's proxy, where Clause 15 applies. Under New Clause 21, the panel must hear from and may question the person seeking assistance and would have the ability to hear from and question their proxy. The amendment would also make explicit that the panel must consider hearing from and questioning parties interested in the welfare of the person and those involved in the person's care. Under new clause 21, the panel would have the ability to hear from any other person, which could include family members, caregivers, and whomever else they deem appropriate. I will give way.
I'm grateful for the Minister to give way, and I appreciate the panel, as it sets out, the new clause does say that they can hear from anybody. But could she confirm that the panel is unable to, as you would with a mental health tribunal, ask people, summon people to appear before them, or insist witnesses appear, and B, make them swear under oath to present that evidence?
Minister? The Honourable Lady is absolutely right. Under the bill as drafted, the panel and the Commission is not invested with powers of summons, and the evidence that is heard and requested isn't conveyed under oath. It's not a court, it's not a tribunal, and those provisions don't apply. So she's absolutely right. They can make the request, they cannot compel someone to attend. Amendment new clause 21E would make it explicit that where considered appropriate for medical reasons, the panel is able to use pre-recorded audio or video material when considering evidence for the purposes of determining a person's eligibility for assistance. Panel procedure would be set out in guidance issued by the Commissioner, which would detail the processes governing the panel process in general, but also for the use of this form of evidence. Amendment New Schedule 2. New Schedule 2, tabled by the member for Spen Valley, builds on Amendment New Clause 21 and introduces a new schedule which further details the composition and the intended proceedings of the assisted dying review panels. Panels, as we've heard, would be formed of 3 members, including a legal member sitting as chair, a psychiatrist, and a social worker. And we've dealt with the provision, thanks to my friend from the member for Richmond Park, in relation to decisions to grant the certificate of eligibility and how that is to be determined by the members of the panel. And we've heard from the sponsor herself that the intention there is that those votes be unanimous, or those decisions be unanimous, I should say. The Commissioner would be responsible for making appointments to a list of persons eligible to sit as members of the multidisciplinary panels and for establishing these panels. Under this schedule, the legal member as chair of the panel must hold or have held high judicial office, be one of His Majesty's Council, i.e. a KC, or have been authorised as a temporary judge of the High Court. The psychiatrist member must be a registered medical practitioner and a practising registered psychiatrist, and the social worker member must appear on the register maintained by Social Work England or Social Work Wales. I am happy to give way.
Thank you, Minister. I'm very grateful for her being so generous with her time. I just want to confirm that the face of the bill, that the social worker required is not a palliative care specialist. Am I right in thinking that?
Minister?
I think you are right in thinking that. There's no specification that be part of the requirements. All 3 panel members would be drawn from from these professions, and as such, subject to the professional standards pertaining to those different professions. In particular, in terms of the legal profession, these are practitioners who are experienced in analysing and reaching decisions based on facts and law. And the professional standards for all 3 of these regulated professions place a high value on not just integrity, but also on impartiality. For the Commissioner and for any judges on the panel, the Guide to Judicial Conduct is explicit that the principles of judicial... I wasn't sure she's making an intervention.
Just on that point, thank you, Chair. Just on that point where she mentioned impartiality, I just want to understand, as it stands, the doctors who would take part in this process would make a choice of whether they would or not. Would that same measure and yardstick be applied to the panel as well, or would they just be appointed? Could they choose not to participate in this process?
Minister?
I anticipate that how this is intended to work is that members of these professions will apply to be members of these panels. There will have to be a recruitment process. That is something that the Commissioner, appointed by the Prime Minister, would undertake. The point that I'm emphasising here is that in putting themselves forward, all of these professions in their different ways, I'm obviously most familiar with the legal profession, and particularly the bar, are governed by professional standards which each specify and place a high value on not just integrity but on impartiality as well.
So just speaking to the point, Minister, thank you. I thank the Minister. Would it be right, I'm just struggling to agree with the position that this would then be impartiality, because you've got people who are committed to and believe in or agree with or are advocates for assisted dying. Would that not then raise a concern for potential bias, subconscious bias even?
Minister.
Well, I think, first of all, there's no doubt that the panel in all of its decisions, as we know, we're going to come to see later, would be subject to public law principles, which include procedural propriety, and any suggestion of bias or even the appearance of bias is an important public law principle. But in any event, the recruitment process, the interviews that would be undertaken, and the professional standards to which all these people would be held, I think that they would be applying their independent and impartial skills and judgment to the decision making and the assessment of eligibility that is appropriate to the task that is set out in the legislation. If they are adhering to their professional standards, which one would expect that all these professionals would do, one would expect them to act with impartiality in going about the business of ascertaining whether the eligibility criteria have been met. So I've got no reason to, as the Minister, or indeed or even speaking for myself, to doubt the independence and impartiality and professionalism rather than any suggestion of bias. Panels would also have to...
Would she get with?
I'm
very grateful. I'm very grateful. Just before she moves on, can she just help us understand whether... I appreciate there's an impact assessment is due to come later, after we've discussed whether we should have this system or not. Nevertheless, could she just let the committee know whether she has informed the sponsor on behalf of whether officials in her department have informed the sponsor, or indeed officials in the Ministry of Health, whether there is sufficient capacity in the workforce of the respective professionals that are going to be required? Has any estimate been done into the numbers that will be required to step forward to take part in these panels? And to her earlier point that the reason that the High Court stage was dropped was not because Ministry of Justice officials informed the sponsor that the family court system would be overwhelmed. Can she confirm that that isn't the case? There was no communication to the sponsor that the courts wouldn't be able to cope with the demand, because that point was very clearly reported in the media at the time. But can she confirm that is in fact not the case?
Minister.
So taking those in turn, the first point is for the impact assessment itself. Clearly, both our departments have data on the state of the professions and how many cases there are in the country and how many would be needed to provide the service. As I said earlier, if Parliament wishes it and legislates for it, then the state will work to deliver it, but the detail will come through in the impact assessment. As to his second question, and as I made clear earlier, this model and the effective shift away from the High Court Clause 12 to the model that we are discussing in this context in the new clauses has been driven by the sponsor's policy intent. I'm not going to get into the specific details of it, precisely the chronology of which, when it was raised, but it came from the sponsor. The fact that there's been commentary, and I hot-footed it from this committee yesterday to oral justice questions, where I saw, delighted to see my friend, the Honourable Member for Reigate, and of course we were discussing capacity issues in our Crown Courts and civil courts, and that, that's well reported in the media. But there is no connection between that and the policy shift that has occurred here. And as I said, if this is what Parliament chooses to legislate, then the state will work to deliver it.
Would the Minister give way
I will.
on that point? I think it's also very important to acknowledge that we are talking a number of years before this law would be implemented. So it's difficult to establish. Hopefully the government will do the fantastic job it is doing of improving capacity in our courts. So even if that were to be an issue a few years down the line, hopefully it won't be.
Minister.
I thank for that encouragement. The government's position throughout this entire process, and insofar as we've worked with the sponsor on these and other amendments to give effect to her intent, is to ensure that they are both workable and operable. If this was not workable, we wouldn't be here discussing it. And indeed, and as was discussed earlier, there are several examples across government where judges or senior lawyers and KCs sit on decision-making panels or in organisations or bodies which sit outside the framework of His Majesty's Courts and Tribunal Service. And we've discussed a number of those examples. The example of public inquiries, I think it speaks actually, and I say this as the Minister of Courts, to the trust and the level of public confidence in both judges and KCs that so often when a public policy challenge, which many of us as politicians struggle to find resolution to, that we turn to judge-led inquiries, KC-led inquiries to establish either what has happened or how systems can be improved, and it's partly because of the impartiality and integrity that they bring to that work. The examples I would offer are the judicial commissioners who operate on behalf of the Investigatory Powers Commissioner, provide independent authorisation of application for the use of the most intrusive investigatory powers. We've mentioned inquiries. I've also already mentioned the parole board as an example of an inquisitorial rather than adversarial panel, often multidisciplinary, where many members of the parole board are often current or retired judges, and they sit and hear these issues of the most complex nature, assessing the risk that prisoners may present to the public on release. I will give way.
Danny Kruger.
I appreciate her point about the parole board. Just to acknowledge that in the parole board there is an essence of an adversarial system there, because the victim is invited to give a statement to the parole board, and the board therefore hears opinions from, as it were, both sides of the case. Who fulfills that second role in the proposals that are before us now?
Minister.
First of all, I draw the comparison for the purpose of showing where judges and legal experts are deployed in a multidisciplinary forum that is not a court or tribunal. I'm not suggesting that there is a straight line analogy. After all, a parole board is performing a different function to make a global assessment of risk. That's what it's ultimately doing. It's not really, strictly speaking, an adversarial process in that sense. But what we have here, and what has been set up in the draft bill, is an individual that is seeking to establish their eligibility for a right which, if passed, Parliament will have conferred on those who meet the criteria. It's not an adjudication. That's not what's taking place here. It's the panel's function, as others have said, and as is clear from the face of the bill, is to assess through the various conversations and provisions and interrogating the information that has been provided, whether they are satisfied and can be soundly and properly satisfied that the eligibility of that person's election to avail themselves of that right is sound, and that they can be satisfied of that. I will.
Sarah.
I'm grateful for giving way, and I am just trying to clarify for my own benefit, because I'm not familiar with some of these procedures. But can I just ask the Minister, is there a difference between having a High Court judge who is leading an inquiry or sitting on a panel? Are they not there to use their legal experience to provide advice or a recommendation or give an opinion, as opposed to a judge who's sitting in the High Court and, as per the wording in the original Clause 12, is giving a direction? And if there is a difference, does the difference, have we not sort of crossed, if you like, from one role to the other in introducing a panel rather than a High Court direction? And does that matter for the purpose of this legislation? Thank you, Chair.
Minister.
Well, again, being absolutely clear that what we are discussing reflects the sponsors intend. I think it's important to break it down. So you have a judge in the role of the commissioner, and the commissioner is going to set up the framework and the guidance of how these panels are going to operate, lending their expertise to that. Again, often our judges sit on procedural rules committee, civil procedural rules, for example, developing the practice that is appropriate to govern the process in question. Here it would be the process of providing the third layer and the assessment of whether the eligibility criteria have been met. The Commissioner is also, as we'll come to see, and this is again where it's distinct from courts or tribunals, providing the monitoring function, the reporting function to Parliament as to how the Act is operating. And again, I think this is also a fundamental distinction from the model we would have if we were to pursue Clause 12, because in that case it would go to whichever High Court judge happened to be sitting that day to hear that particular, or consider that particular application for an assisted death. No particular expertise on the part of the High Court judge, no reporting function to assess the operation of the Act. So it's a different model that the sponsor has elected for. But to answer her question fully, in relation to the panel, which is going to deal with the individual determination in respect of an individual applicant seeking a certificate of eligibility, you've got a legal member there who may be a judge, may not be, may be a KC. They are there not as a judge, as the sponsor has said. They're there as a panel member exercising the function of the panel alongside the other experts. So I hope that provides some explanation, as the government sees it, to how the model that the sponsor has chosen would operate. I come to new Schedule 2A. This is the Welsh language amendment. New Schedule 2A regards New Schedule 2, which details the composition and proceedings of assisted dying review panels. The amendment would make it a requirement that each member of the panel must be fluent in the Welsh language if services or functions in the Act are to be provided to an individual in Welsh. Panels, as we've discussed, must consist of a legal member, a psychiatrist, and a social work member, all of whom, under this amendment, would be required to be fluent in the Welsh language. The proposed amendment, from the point of view of the government, would cause significant operational challenges, as it would require there to be enough members of all three of those professions who are fluent in Welsh and have applied and been appointed to the pool of panel members in order to convene a panel that may be required given the circumstances at short notice. I will.
Liz Saville-Roberts.
This situation exists already in Wales when we're looking at the situation of coroners, where people are prepared to travel in order to facilitate Welsh language, Welsh medium inquests. And of course, we have local authorities, where, such as Gwynedd, my own, where it is a requirement that all social workers are able to work through the medium of Welsh, and the requirement will already be there. It will be a process of acknowledging those psychiatrists who will be able to do this. This is critical for this piece of legislation if we are to put the person and the needs of the person first. I would really urge the Minister to consider this, because it is a matter with digital technology, with the operations we already have to put in place in order to allow people to use their language in Wales. We are already familiar with this. This recognises the dire situation, the absolute urgency of people at this most stressful time in their lives to be able to use the language they prefer.
I thank her for that intervention, and I do want to reassure her about the provisions that would apply, even if her amendment were not taken. The Welsh Language Act 1993 requires public bodies, either named in the Act or named by Welsh ministers, which provides services to the public in Wales, to prepare a Welsh language scheme, setting out the steps the body will take in relation to the use of the Welsh language while providing those services. Now, this approach is used, as I understand it, all the time in legal proceedings in Wales. And in the instance where a party wishes to speak in Welsh at the proceedings, then Section 22, as she will know, of the Welsh Language Act 1993 will apply. Any party to the legal proceedings can speak in Welsh, can express themselves in Welsh, at which point a Welsh interpreter would be commissioned to facilitate the discussion. That will happen. That would be the status quo, or the backstop, if you like, without this amendment. The significant operational challenges that requiring all members of the panel to speak fluent Welsh would be, in the government's view, a significant challenge, and one which could lead, I will give way, just want to finish my sentence, and one which could lead to undue delay when we are talking about the end of life. I will give way.
Tom Gordon.
Thank you, Minister, for giving way. I only speak one language, and it's definitely not Welsh, even though I did have a stint working in Wales. With any language, there can be things that are lost in translation. And when we're talking about something like assisted dying, does she acknowledge that even with very skilled interpreters, there would have to be such a level of training to make sure that everything was fully thought through and that there was no cracks and nothing would slip through the net? That's not covered under the Welsh Language Act currently, and that's why the amendment has been tabled. And does she appreciate the sort of the severity of that?
Minister. I thank him for that intervention, and all three members sat over there have put their case incredibly powerfully on this point. But I would, in emphasising the operational difficulties that government has identified, make this point: that the approach under Section 22 of the Welsh Language Act, where the ability to speak in Welsh and have the interpretation services is adopted in very, very serious legal proceedings indeed. You're right. We're talking about, nuances which can determine civil or criminal liability. I mean, these are very, very serious issues indeed. I'm not saying that's quite as serious as matters of life or death, but in terms of the sorts of things that interpreters need to ensure they're getting right, as well as vindicating the person's ability to express themselves in their mother tongue or their preferred tongue, it is something that happens already and would happen under the operation of the Act.
I wonder would she appreciate that when it comes to Welsh speakers using their language in the face of the majority language English, the status, what we are doing here is putting another barrier in their way. Another, I am making a nuisance of myself. I have to ask a favour and getting interpreters. That is not what we should be doing with this piece of legislation. We should be putting those people first and making sure that they can express themselves at this most emotional time as effectively as possible. And interpreters should not be in the room with these assisted dying panels. It's fundamentally against the nature of this bill.
Minister.
I appreciate the sort of passion and the force with which she makes that point. I think I've set out government's concerns about the deliverability and the operational challenges around delivering this. But in applying Section 22 of the Welsh Language Act to the Commissioner, who under the sponsors' amendment to introduce new Schedule 2 would be able to give guidance to panels on how exactly it should facilitate exactly what she is seeking, the ability of that dying person who is seeking an assisted death to express themselves through the Welsh language within these most sensitive of proceedings. That could be facilitated by the Commissioner in order to commission an interpreter and assist the person to speak in Welsh. I appreciate she feels that would create a barrier that is not appropriate to this context, but I think it is a reflection of the fact that certainly government is not seeking to stand in the way of people expressing themselves in Welsh. It wants to vindicate that, and that's in line with our wider commitment to devolution, to working with the devolved governments in the context of this bill. But I think she's made her point forcefully, and no doubt the committee will come to vote on this amendment, but I have to, on behalf of the government, acting responsibly, lay out some of the challenges that will mean to the operability and the deliverability of the bill. I will give way.
I thank the Minister for giving way, and I accept that she's in a difficult position because she's presenting the case for the government's position and can't take a position herself. I would just gently ask if she accepts the weariness of Welsh language speakers and campaigners over generations who have been faced with the same argument time and time again of operational challenges, whatever that issue may be. and suggest to her that perhaps it's time the government stopped using that excuse.
Minister?
I thank her for that intervention. She's heard the government's position in terms of the operation. And as I said, it is important that, that in the event this amendment is not taken forward, that the points and the force with which they're made, I think, would be fed in to the Commissioner and the Commissioner's modus operandi in order, as far as possible and within what resources allow, to allow people to express themselves in the Welsh language. And as I said, I want to put on record our continued commitment to devolution in this context and to working through with the Welsh Government to resolve any of the outstanding legal and technical and constitutional issues that may arise in a kind of thoughtful and constructive way.
I will do. I really am grateful. The constitutional issues that we are discussing here, surely many of these should be issues that would be decided by the Senate and by Welsh Government, and that it is a matter of urgency now where we discuss the appropriate authority, which is used in other pieces of legislation. I believe in the crime and policing legislation, appropriate authority is used in relation to England and Scotland, that we need to have clarity on these decisions as we move ahead.
She is absolutely right. We do need to get clarity because, as the sponsor has made clear, the intention here is for the Act to apply across both England and Wales, and it's a single commission. That's the model that's being proposed under these new clauses, and so she's right that we do need to ensure that close working in order to ensure that those technical and legal issues are resolved. New Schedule 2B, this is the official solicitor issue. Amendment New Schedule 2B seeks to establish a process through which a person nominated by the official solicitor acts as an advocate to the panel. The official solicitor, it's important to remind ourselves of the role that the official solicitor typically plays, acts as a litigation friend, and where they do act as an advocate to the court, the purpose of that function is to assist courts on a difficult or novel point of law. The focus of the official solicitor is in representing adults who lack mental capacity and children. Now, both groups are plainly out of the scope of this bill. This is about someone who has capacity and who is applying for an assisted death. This amendment would therefore require a significant and radical change in the official solicitor's function and focus. Under the sponsor's amendment, assisted dying review panels would have their own powers to determine whether requirements of the bill have been met, including, as we've noted, the ability to hear from and question any other person.
On that point, I'm grateful for the honourable member the Minister for giving way. She's been very generous with the time. I just want to understand, when she says it's the official solicitor is there to help with adults who lack capacity, in the case of the Court of Protection, we have 9 girls out of 10 who lacked capacity, and yet the judges took a decision to not to force feed them. And these were girls who had anorexia, and not to force feed them, the judges concluded they lacked capacity, and yet they were on a pathway. The judges also accepted these girls were going to inevitably die. So in that case, wouldn't it be sufficient? Wouldn't the role of the official solicitor be helpful? Wouldn't that meet that criteria, just as a further safeguard?
Minister?
I think that it's important that we look at this in the context of what the sponsor member is setting out to do through the legislation and what the panel's function is, and it's the function that was discussed in the debate. This isn't a trial or an inquiry. That's not what's being undertaken by the panel. The panel's purpose is to ensure that the process of the eligibility criteria has been followed in a correct, lawful and safe way. It's not, as others have pointed out, adversarial in terms of how it's been described on the face of the bill. And because the official, all I'm saying on behalf of the government is because the official solicitor's role is most frequently in terms of assisting in court where the person cannot do it themselves with a difficult or novel point of law. Well, we don't have that here. We're not determining points of law. We're determining whether this person has met the eligibility criteria. Second, their role is where individuals lack capacity. Here, by definition, the person who's applying has already satisfied 2 doctors that they have capacity. Of course, the question of capacity may be something the panel wishes to explore further, and it's got the 3 panel members and the ability to draw on its powers to seek further information to test that. But it's not clear, without altering the current role that the official solicitor plays within our legal system, what role they would be serving.
I'm grateful for the Minister to give way, and I appreciate her position. I'm really grateful for her explanation. That doesn't address the central point, which is, for me, there are 9 girls who were deemed not to have capacity. And there is all the amendments that have been tabled and the letter even from all the charities about anorexia specifically have not been addressed. So in absence of any impact assessment, one of my most frustrating issues that frustrates me, how does the government conclude that this bill, the workability of this bill is sufficient and it would work, given that we do not have that protection for those girls who may have anorexia, and in this there has been precedent where they did not have capacity. How will this government be safeguarding those girls in particular?
I thank you for that intervention. I know this is a case that she has brought up a number of times when we've been debating various stages of the bill. What I would say in this context is one of part of the provision that allows, in terms of the design and the operation of the Commission and the panels to which the various cases are referred, is the development of guidance. If there is specific processes that the Commissioner deems appropriate to the consideration of applications for assisted death where anorexia is an issue, for example, the case she raises, then that guidance can be developed. And again, of course, it's a matter for the sponsor, but one might have thought that having a dedicated body in relation to assisted death that also has the monitoring function that we're going to come to see in clause 34 is the development of expertise in terms of dealing with cases, particularly those particularly difficult cases of the nature she raises. That is something from a government point of view that wouldn't necessarily flow, or it's hard to see why it would flow at all, from the High Court if we revert to that. I mean, it's a distinction between the 2 models that the sponsor has explored.
Will the Minister give way? I will. On that point, just on that point, I think that's another really important argument for having the panel. In instances where a terminally ill person who may have an eating disorder has been deemed to have capacity by 2 doctors and I would surmise a psychiatrist as well, now that we've got the compulsory referral, we now have on the panel another psychiatrist and a social worker. So in terms of the concerns around capacity, I think the panel does have to address that. Would the Minister agree? Minister?
Well, obviously, the member for Spen Valley has developed her thinking, and government, as I've said, has worked with her to reflect that policy intent. But I think that's right. I think it is capable of doing just that, and could operate in that way. New Schedule 2C. This is the issue around domestic abuse training. Amendment New Schedule 2C would make the Voluntary Assisted Dying Commissioner responsible for ensuring that all members had received training in respect to domestic abuse, including coercive control and financial abuse. Persons appointed to the list of eligible panel members would, as we've seen, already be qualified in the fields of law or psychiatry or social work, and all the training that pertains to receiving professional qualification in those fields. In addition, under the sponsor's amendment to introduce New Schedule 2, the Commissioner would be able to give guidance to the panels, which could include training requirements, which the panels must have regard to in the exercise of their functions. So that's all I propose to say about that. It might be seen as an example of something that would typically, I'm not saying it has to be here, but typically would be left to either regulation or to the guidance itself rather than being in primary legislation. New Schedule 2D. This is the question of the panels sitting in private or in public. Amendment New Schedule 2D seeks to ensure that panels would sit in private by default.
If I may, for a moment, I think, Minister
Kit
Michael,
Malthouse.
I'm not sure my amendment was selected. Unfortunately, I missed the deadline, so she doesn't need to cover it anymore.
So at which moment I will now suspend the sitting.
Put us all out of our misery.
For, I didn't wish to say that, but the Minister did. And then we could all come back at 5:10.
Debate on Clause 12, stand part, resumed. Minister has the floor. Minister.
Thank you, Sir Roger. It's a pleasure to serve this afternoon under your chairship. I come to amendments new clause 17. The members for Spend Valley's new clause 17 would establish an internal review process. Where a panel refuses to grant a certificate of eligibility, the person seeking assistance would have the option to apply to the Commissioner for their case to be reconsidered on the grounds that the first panel's decision contained an error of law, is irrational or is procedurally unfair, essentially public law grounds. If the Commissioner is satisfied that any of these grounds apply, having considered the case without a hearing, they must refer the person's case to the second panel for a fresh determination. The Commissioner would be required to give reasons in writing for their decision. This decision should be shared with the person seeking assistance, the coordinating doctor, and any other person specified in regulation. In addition to this internal review process, decisions made by the Commissioner or a panel would be amenable to judicial review. It would be for the court to decide whether an individual or group is sufficiently impacted to have standing. New clause 17A. This is in relation to proposed change to who can apply for reconsideration of the initial panel decision. Amendment new clause 17A, tabled by the member for Reigate, seeks to make changes to the process of applying to the Commissioner for reconsideration of a panel's decision as set out in new clause 17. This amendment would widen the range of persons eligible to apply for a reconsideration to include not just the person seeking assistance, but their next of kin and other relatives, the medical practitioners who are treating them, and any other person who engaged in the first panel's proceedings. Secondly, the Commissioner would be able to allow the application for reconsideration on the basis that the first panel's decision was wrong or unjust because of a procedural or other irregularity in the proceedings. This could include scenarios where a person wishes to challenge the panel's decision to grant a certificate of eligibility. Wrong is a unspecific and subjective and uncertain term which is not typically used in legislation for these reasons. It's a far broader criteria than that set out in new clause 17 and would give the Commissioner a significant degree of discretion as to whether to exercise the power to have the matter reconsidered. Lastly, this amendment would make it mandatory for the Commissioner to consider each reconsideration with a hearing unless they considered it to be in the interest of justice to proceed without a hearing. This could increase the length of time taken to complete the process and the complexity of the process. In addition to the internal review process under new clause 17, decisions made by the Commissioner, any decision, or any individual panel would be amenable to judicial review. It would be for the court to decide in each and every case whether an individual or group challenging any such decisions is sufficiently impacted to have standing for the purposes of judicial review.
Would you give way?
I will give way.
I'm very grateful. I'd just be grateful for her advice, her view on whether she thinks that a family member would always have standing. I appreciate her point that that would be for the panel itself to consider, but is it her view in law and in our experience that family members, and again we're conscious of the definition of what family members is, but in the normal understanding of the term, would have sufficient standing, or can she foresee circumstances in which they could conclude that family members did not have sufficient standing to make that representation?
Minister.
So he asked a question in terms of standing, in terms of the process of judicial review. I think it's fair to say that in the development of our public body, our corpus of administrative law, that the rules of standing are fairly liberal, having a sufficient interest to bring the case. Of course, the case needs to be meritorious and it would need to meet the permission threshold, which again is a relatively low standard. Does one have an arguable case? So in terms of standing, a family member who has identified a procedural irregularity or a public law error, which is arguable, I would have thought would have standing to bring a judicial review. And of course, we're talking about, I think in the question he asked me about the potential for judicial review of individual decisions to issue a certificate of eligibility, but of course any decision of the Commission, the Commissioner and any of the subordinate panels would be amenable to judicial review. So for example, the decision to issue guidance, guidance documents, policy documents relating to the operations of the Commission would be amenable to judicial review. And again, one can imagine under our broadly liberal views of liberal rules of standing within the administrative court, that a range of bodies, not even pertaining to an individual case, an individual, their families, but actually bodies that have an interest in those rules might well be eligible. Ultimately, and I would say this as the Minister of Court, for courts, that's going to be a matter for the independent judiciary, but it's right that within our public law system that the rules of standing are fairly broad. Amendments, new clause 2, new clause 3, 61 and 70. So these deal with the amendments, and I believe this was the member for Runnymede, in relation to the creation of a tribunal. So a further alternative to what we've heard about the High Court, the Commission, and now the proposal for a tribunal. New clause 2, new clause 3, and amendments 61 to 70 would replace the proposed High Court stage within the bill with the first tier tribunal. Tribunals are designed to be more informal and accessible than courts, with subject matter expertise represented on the panels. We're familiar with the Employment Tribunal, the Immigration and Asylum Tribunal, the Property Tribunal, and so forth. Under this clause, people seeking assistance would be required to apply to the first tier tribunal for a declaration that the necessary requirements in the application for an assisted death had been met. Indeed, under the proposed amendments, there are parallels with the process that would be intended to follow under the panel and commission model. The requirements under this clause are the same as under current clause 12.3, but with the addition of 2 further requirements: that the person has relevant and available palliative care options available to them, and that the person is not liable to be detained under the Mental Health Act. The tribunal under this clause would have the same powers as the High Court in the original draft of the bill in relation to making the assessment, including the ability to speak to the patient and both the coordinating and independent doctors. The tribunal panel considering each case would be required to be formed of a sitting judge, a medical practitioner and a layperson. Including the specific membership of the tribunal panel is a departure from the normal tribunal arrangements, under which the responsibility for determining panel composition is delegated to the senior president of tribunals. As I've said, the tribunal model set out in these amendments shares some similarities with the sponsors' amendments to introduce the voluntary assisted dying panels. However, tribunals are typically, although not always, adversarial in their nature, with 2 opposing sides. They're adjudicating in a dispute. It would be the government's policy that any tribunal should fall within the Unified Tribunal structure and therefore be governed by the Tribunals, Courts and Enforcement Act 2007. An assisted dying commissioner, as we've discussed, would have greater flexibility to set the procedure of the panels than a tribunal, because they'd be outside the tribunal structure. Additional duties can be placed on the commissioner, the reporting function and monitoring function in terms of the operation of the Act that comes in clause 34. These are all features that apply to the Commission and the voluntary and the Commission model, but wouldn't apply to a tribunal model. So therein, I think, lies the difference, and the sponsor has given her reasons for why she prefers the Commission model. As I said earlier, the government has taken a neutral position on the substantive policy questions pertaining to how the law in this area could change, and it's ultimately a matter for the committee and for Parliament as a whole. But I hope that those observations have been helpful to the members of the committee in considering this important clause.
Thank you, Chair. And it's a pleasure to serve under you this afternoon. Can I start by saying what an absolute delight it was to see the member for East Wiltshire's mum here today. What a delight. Sadly, I think she's no longer here in the room today, but I hope he and her had a really good chat this afternoon, of course.
I'm sorry to report my mother couldn't hear a word of the proceedings. No, I'm exaggerating, but she was grumbling about the mumbling that was going on in this. So it's a lesson for us all, don't you agree, Sir Roger?
We've all been told off. You're quite right. So I thank colleagues for what has been another really powerful, robust, thorough debate on this really important subject. And I thank the Minister for providing such an excellent and clear description of the proposed changes to New Clause 12, which I'm making this afternoon. And as such, I won't repeat that description. Look, this bill is already the strongest of its kind anywhere in the world. And with these proposed amendments, it will be made even more robust. And of course, as we've heard, it's much safer than the current ban on assisted dying, which leaves terminally ill people and their families without any such protections at all. The proposal to have a multidisciplinary panel appointed by a judge to examine each request, following earlier assessments by 2 independent doctors and potentially, where necessary, a psychiatrist, reflects the expert testimony we have heard during our proceedings. It strengthens the bill by adding more and varied expertise to the decision-making process with judicial oversight, and includes an important function in terms of monitoring and reporting through the Commissioner. This is the committee process working exactly as it should, reflecting on evidence from the UK and around the world and making a strong bill even stronger. While I appreciate, for procedural reasons, we won't be voting on the replacement for Clause 12 until the new clauses are put at the end of the committee stage, I have been encouraged that in the course of this debate there have been positive responses and comments to the proposal for a Commissioner and a multidisciplinary panel from colleagues across the committee, regardless of how they voted at second reading. That tells me that whatever our views on the bill itself, there is a shared commitment to getting protections for terminally ill adults right. That means we are doing our job. Chair, I'll turn briefly to some of the amendments that have been proposed this afternoon. With regard to amendment to new Schedule 2 from the member for Lowestoft, I was really pleased to support the amendments from my honourable friend in relation to additional training with regard to domestic abuse, coercive control and financial abuse for doctors who take part in the assisted dying process. As the members appointed to the panel are already very well qualified in the fields of law, psychiatry and social work, I am confident that they will have the necessary expertise to determine referrals, but I also appreciate the challenges around detecting the subtleties of coercion, as we have discussed at length in this committee, and as such I am supportive of this amendment. I now turn to the proposed amendment to new Schedule 2 from the Honourable Member from Plaid Cymru. Chair, I am fully supportive of the member's position around ensuring accessibility and equality for Welsh speakers. But in this instance, I do have some concerns about the barrier this amendment may create for patients in accessing the assisted dying process in a timely manner, and therefore the workability of the amendment. And as the Minister has said, under the Welsh Language Act 1993, all public bodies operating in Wales must create a Welsh language scheme with the aim of ensuring that Welsh and English are treated equally in all aspects of public service delivery. The Ministry of Justice's Welsh Language Scheme, for example, sets out where services can be provided in Welsh, typically through translation services. But I also take on board the Honourable Lady's comments about the limitations of using translators. And given the sensitivity of the conversations that and the deliberations we're discussing, I think this is something we need to be very sensitive to. And I think it would, of course, be the patient's prerogative to request a fully Welsh-speaking panel if that was what they wanted at such a difficult time, as long as they were made aware of the potential delays that may or may not create, because that would be my concern. But I think her intention and my reading of her amendment is that this would not be required in every case. But what it would mean, that it would be a very patient-centred approach, which is something I believe passionately in. So I do take on board the concerns raised by the Minister from the Government's position, which I appreciate may need to be considered further down the line, but I am minded to support the Honourable Lady's amendment this afternoon. And finally, the Amendment E to New Clause 21 from the member for... Is it Claire Hazelgrove? Yeah?
E or D?
Filton and Bradley
Stoke.
Filton and Bradley Stoke. I will apologise to the Honourable Member when I say Filton and Bradley Stoke regarding audio and video material. Again, I think this is coming from a really personal place and a very sensitive and important place. And I think it again demonstrates a very patient-centred approach. So I'm also minded to support that amendment this afternoon. Other amendments, I welcome the clarity from the Minister with regard to some of the legal language and terminology around other amendments, and as such I won't be supporting them this afternoon. But I think we've had another very thorough debate, as I say, and I really welcome contributions from colleagues across the committee this afternoon.
That concludes the debate on Clause 12 stand part. Members will understand that we shall now debate only, we shall now vote only on Clause stand part. The other amendments, new schedules and new clauses will all be voted upon as they are reached in the course of the programme. So the question is that Clause 12 stand part of the bill. As many of that opinion say aye? Aye. The contrary, no? No. Division.
Division room 10.
Block the doors.
Jack Abbott. No. Lewis Atkinson.
No.
Juliet Campbell.
Aye.
Bambos Cheryl Ambos.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green.
No.
Rachel Hopkins.
No.
Sojourn Joseph.
No.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Mothouse.
No.
Sarah Olney.
Aye.
Dr. Simon Ofer.
No.
Rebecca Paul.
Aye.
Sarah Sackman.
No.
Liz Saville-Roberts.
No.
Naz Shaw.
Aye.
Dr. Neil Shastri-Hurst.
No.
Dr. Mary Tibble.
No.
Sean Woodcock.
Aye.
The ayes were 7, and the noes were 15. So the noes have it. Unlock. Actually, don't unlock. Leave the doors locked. We now come to Amendment 371, Clause 13, which has already been debated with Clause 12 stand part. Kim Leadbeater to move the amendment formally.
Move formally, Chair.
The question is that Amendment 371 to Clause 371, as on the order paper, be made. As many of that opinion say aye? Aye. Contrary, no? No. As many of that opinion say aye? Aye. Contrary, no? No. Division.
Division room 10.
Jack Abbott. Aye. Lewis Atkinson.
Aye.
Juliet Campbell.
Aye.
Bambos Cheryl Ambos.
Aye.
Daniel Francis.
No.
Tom Gordon.
Aye.
Sarah Green.
Aye.
Rachel Hopkins.
Aye.
Sojourn Joseph.
Aye.
Stephen Kinnock.
Aye.
Danny Kruger.
No.
Kim Leadbeater.
Aye.
Kit Mothouse.
Aye.
Sarah Olney.
Aye.
Dr. Simon Ofer.
Aye.
Rebecca Paul. Sorry. Jake Richards.
Aye.
Sarah Sackman.
Aye.
Liz Saville-Roberts.
Aye.
Naz Shaw.
No.
Dr. Neil Shastri-Hurst.
Aye.
Dr. Mary Tidball.
Aye.
Sean Woodcock.
No.
The ayes were 18 and the noes were 4, so the ayes have it. Unlock. We now come to Amendment 469 to Clause 13 in the name of Kim Leadbeater, with which we convene to take Amendments 470 to 472. Kim Leadbeater to move Amendment 469.
Thank you, Chair. These amendments, 469, 470, 472, serve simply to set out clearly what the regulations must include with regard to the second declaration and the subsequent statement from the coordinating doctor. They replace the schedules and are consistent with the advice I've received that matters of this nature are not suitable for the face of the bill. Very simple, straightforward amendments.
Amendment 469 to clause 13 as on the order paper proposed. As many of that, Minister?
Thank you, sir. Yes, I just want to say a word on this one. Thank you. And it's a pleasure to serve under your chairship. On these amendments, we've been working with the member for Spen Valley, and changes have been mutually agreed upon by herself and the government. These aim to ensure the bill, if passed, is legally and operationally workable, and I will just offer a technical factual explanation and rationale for these amendments. 469 and 472 are supplementary to Amendment 208, which provides that the form of the statement made by the coordinating doctor in relation to the second declaration is to be set out in regulations. Amendment 472 sets out the information that the regulations must require the statement to include, as well as some additional declarations by the coordinating doctor. Amendment 470 is supplementary to Amendment 207, which provides that the form of a second declaration is to be set out in regulations. This amendment sets out the information that the regulations must require the second declaration to include, as well as some additional declarations by the person. This applies to regulations made under clause 13, subsection 3A. I hope that was useful for the committee.
Kim Ledbetter.
I have nothing further to add, Chair.
Amendment 469 to clause 13 as on the order paper proposed. Questions that the amendment be made. As many of that opinion say aye. Aye. Contrary no. The ayes have it. We now come to Amendment 317 to clause 13, which has already been debated with Amendment 301. Does anyone wish to move that formally? Not moved. Amendment 372 to clause 13, which has already been debated with clause 12 stand part. Kim Ledbetter to move formally.
Move formally, Chair.
Amendment 372 to clause 13 as on the order paper be made. As many of that opinion say aye. Aye. Contrary no. The ayes have it. Amendment 373 to clause 13, which has already been debated with clause 12 stand part. Kim Ledbetter to move formally.
Move formally, Chair.
The question is that Amendment 373 to clause 13 as on the order paper be made. As many of that opinion say aye. Aye. Contrary no. The ayes have it. We now come to Amendment 457 to clause 13 in the name of Sarah Olney, with which it will be convenient to consider Amendments 471, 316 and 374. Sarah Olney to move Amendment 457, please.
Thank you, Chair. It's a pleasure to serve under your chairmanship. I have brought forward this particular amendment just to exclude the possibility that somebody could render themselves, if that's the appropriate language, terminally ill by the mechanism of voluntarily stopping eating and drinking. The bill before us is based on the principle that assisted suicide should be limited to those who are already dying, those with a terminal illness and a prognosis of 6 months or less. But there is growing evidence that this safeguard could be undermined by a practice known as voluntary stopping of eating and drinking, or VSED. VSED is when a person with mental capacity deliberately chooses to stop eating and drinking with the intention of hastening death. It's sometimes framed as an exercise of choice at the end of life, but in jurisdictions where assisted suicide is legal, it's increasingly being used as a means to an end, a way for individuals who do not meet the legal definition of terminal illness to qualify for lethal drugs. So the logic is simple. A person has the right to refuse food and water. If they do so, their health deteriorates and they may die within 6 months. Some doctors have accepted this as grounds to certify a patient as terminally ill, not because their underlying condition would have led to imminent death, but because of the self-imposed effects of dehydration and malnutrition. This strategy has only become viable because many jurisdictions have shortened or removed waiting periods for assisted suicide. The loophole works only if the time it takes to obtain lethal drugs is shorter than the time it takes to die from refusing food and water. And under this bill, the same loophole exists. Clause 13, subsection 2b, states that if a doctor reasonably believes that the person's death is likely to occur within 1 month, the standard 14-day waiting period can be reduced to just 48 hours. So if a person stops eating and drinking, their death will almost certainly be likely within 1 month. So in other words, a person who's not terminally ill could make themselves eligible for an assisted death within 48 hours simply by refusing sustenance. Now, proponents of assisted suicide have been explicit this is not simply a theoretical possibility, it's a coordinated strategy. With pleasure.
I might be missing something, it's been a long day, but presumably by the time the patient has got to this point, they've been through the eligibility criteria with the two doctors. So you just said if they wouldn't, so she just said if they wouldn't be terminally ill, but they would have been through all the assessment criteria to this point. And the panel.
And the panel. Just taking the opportunity to have a quick glass of water while you spoke. Give me a minute. Thank you for that intervention. I think the point is that we want to preclude the possibility, at whatever stage it might happen, that somebody could deliberately render themselves terminally ill by the voluntary stoppage of eating.
Sorry, forgive me. Will the Honourable Lady give way? I share the sponsor's confusion. By the time we get to clause 13, my understanding is that the person has already satisfied the eligibility to two doctors and to the panel. So they are by definition terminally ill. So I don't understand why they would then seek to render themselves doubly terminally ill by adding the characteristics that she's explaining. Maybe I'm being confused, but I could understand a case if she was making it way before, but at this stage the person's been through two doctors and the panel, got permission to go ahead. Why then they would starve themselves, I don't understand.
Thank you, Chair. The point is that they may use the opportunity to take the further provision that exists for people whose death is expected within 1 month.
But they don't need to if they've got to this stage.
Order!
Sorry. Forgive me.
Thank you, Chair. I take the point, but I still think it is necessary to have this additional safeguard in order to close a loophole that people could, as I say, render themselves terminally ill within the space of a month and use the opportunity which is presented in this bill with the additional provision that if someone of reducing the 14-day waiting period. I would just sort of end my remarks by saying that this is a real concern of people who have reviewed this legislation, because the possibility exists, and it has been seen in other jurisdictions, that people could. I don't want to necessarily adopt the honourable gentleman's language, but hasten the extent to which they become eligible for assisted dying through this particular method. And all I'm asking for is that if we close that loophole, if we close that down, then and therefore people will not be tempted to follow this very damaging path. Thank you, Chair.
I beg to move that further consideration of this bill be now adjourned.
It would have been helpful to have been able to move the amendment first, but the motion has been put. The question is that further consideration be now adjourned. Does many of that opinion say aye? Aye. Contrary, no. Ayes have it. Order, order.